It's a contempt, which is, we have been made as a contemptor, but already the order was complied. Petitioner has filed. We are one of the contemptor. One. So we came to know there is another direction passed by this court saying that there has to be a fresh demarcation. Already it has been demarcated. Compliance report has been furnished. So without hearing us, that order has been passed. So if it is not inconvenient to your lordship, my lord, can you be listed tomorrow if it is convenient?
Fresh matter.
Fresh, we are appearing. This is it is a pending matter, but we appeared for the first time now, man. If it
Why
is
tomorrow?
possible, my lord, tomorrow. I have
See, you are
come-
making a request, we may not, will not normally decline, but this is not a case for out of turn mentioning.
I know, I know. No, what has happened? Why now I'm saying?
Let us follow our standard
No, I'll
practice.
tell your lordship what has happened, that there is already an order, demarcation, fresh demarcation, it is on 19. 19 again, fresh demarcation. My lord, a notice should have been issued with greatest respect, I'm saying. I don't mind, my lord, but their notice should have been issued before a fresh demarcation, without giving a notice to us, my lord.
Okay, 18th we'll have. 18th, Monday,
No, no.
18th.
18th. Well, another matter, this is about.
Now, had it been a fresh matter, there is absolutely no problem. But contempt matter, that too contempt. We don't normally. Yes, what is the second matter?
No, but this is what I was trying to impress your lordship, that why urgency was there. The urgency was there because.
Now, what will happen on 19th?
No, they will, fresh demarcation will take place, nothing remains in my case. Fresh demarcation.
Nothing will happen. Demarcation is not handing over position.
No.
Okay, next matter.
No, that's the whole problem. There's an order passed by this court saying that the possession of the party should not be disturbed. And there is already a compliance report furnished.
Okay, what would 18th will have? And what is the next matter?
The next case is about election to the post of resident, Jila Parishad.
Fresh motion matter.
motion.
Motion you can have anywhere.
Tomorrow,
no problem.
Sorry for troubling.
I beg to beg, sir.
Yes.
I'm very apologize to mention item number 14, hearing limit. I'm appealing I'm appealing on behalf of GST, your lordship.
Okay.
1 day accommodation is required, your lordship.
But this is an old matter.
2024,
14 or 2000. Okay,
your lordship. We have filed our affidavit. GST.
okay, no problem. When
Only
do you
one
want?
day.
When do you want?
Day after tomorrow, or any date, your lordship.
After tomorrow. What's for the other side? Mentioned, informed.
Yes, I had it.
Okay.
GST, your lordship.
Okay. Dr. Gogoi, the learned standing council, GST.
No.
CGST
your lordship.
has paid for an accommodation. List on Tuesday next Tuesday, huh? For hearing.
I'm deeply obliged, lordship.
I beg for listing of a fresh of a writ petition pending.
New matter, yes. When?
Any day next week.
Yes, it will come otherwise also. Why do you have to mention? Have you filed or not?
It's a pending 2024 writ petition.
Then it's not a fresh matter.
No, not a fresh.
Then 24 matter, why out of turn listing?
Lordship, because the bank account of the petitioner has been freezed by the respondent bank, and that is the only source of livelihood the petitioner.
When was it last listed?
It was listed in the month of May.
What was the order passed?
Order. Some adjournment was taken.
What was the order passed? Listed after how many days?
2 weeks. It has passed, Lordship.
Okay, next Wednesday. Next Monday.
Obliged.
May it please, Lordship, I beg to mention for listing to WBC pertaining to Gaon Panchayat, Lordship.
Fresh matters.
Yes, Lordship.
Fresh matters, yes, whenever you
Can we
wish.
fix for tomorrow, Lordship?
Tomorrow is, yes.
Must
Have you
oblige.
filed or not?
Yes, already fine, Lordship. Most obliged.
Let me lead around.
Yes.
My lord,
Yes, Mr. Doctor, yesterday's matter.
yes.
Yes, my lord, the lordship may see the impin order at page 26.
Yes.
My lord, at this stage, my lord, possibly I'll require 2 weeks' time. In the meantime, he is not going to be, my lord, the construction is not going to be demolished.
Okay.
45 days
Okay.
time has been
Okay,
given.
okay. But yesterday, the State Counsel, Mr. Sharma, had pointed out something which you have recorded in the order.
Well,
It is not that he was not given a chance. The adjournments were sought at least on 3 occasions.
yes, yes.
And thereafter, the order has been passed. It's not that there is
Well,
violation of principles of natural justice.
The-
You were given an opportunity.
Yes, the
You do
opportunity
not
is-
come. Then can you come to the court and say that I was not given an opportunity?
That is
But
possibly.
you take the instructions on merits.
Yeah.
There may be something.
My lord, in the reply, my lord, we have stated the pendency of the, my lord,
That is the reason we are inclined to
yes.
entertain this matter. Heard 3 pieces, learned counsel for the petitioner who is aggrieved by an order dated.
Lord, your
No,
lordship may,
don't write that.
your lordship may say another thing. So for respondent number 1, now we are, my lord, Silchar Municipal Corporation. And it has been warded as Silchar Municipality represented by the executive officer. This is not correct. So I think that part will have to be amended.
Yes, okay. Don't write. I heard 3 pieces, learned counsel for the petitioner. This matter was taken up for consideration yesterday when the following order was passed. Para 3. As Dr. Learned Senior Counsel is present today, full stop. Present today and has submitted that appropriate instructions would be obtained in this regard, full stop. Let notice be issued. Returnable by 2 weeks. Ms. Musari, you are for one.
For no 1, my lord.
Learned counsel assisting the senior counsel for the senior counsel Sri Doctor accepts notice on behalf of respondent number 1. 2 and 3. H. Sharma, additional senior number 2 and 3. Extra copies. 4 by registered post with AD. Steps within 2 days. Not 2 weeks then. 4 weeks. This has to be served. 4 has to be served.
Yes, 4 is to 7.
Okay, para. Sri Doctor, the learned senior counsel has however pointed out that the respondent number 1 has not been properly the nomenclature of the respondent number 1 is not correct, and it should be Silchar Municipal Corporation. Full stop. The learned counsel for the petitioner may take appropriate steps in this regard. Para. 3. Learned counsel prays for an interim order. Para. Sri Dr. The learned senior counsel for the respondent number 1 has submitted that till the returnable date, no exercise of demolition
Yes.
would be carried out. Para. In view of the aforesaid undertaking, comma, it is directed that till the next returnable date, status quo as on today of the semi-RCC house of the petitioner shall be maintained.
Obliged.
Para, it is clarified that the interim order would, however, be reconsidered after obtaining of instructions.
Obliged.
Take steps within 2 days. Serve extra copies, Mr. Secretary.
My lord.
May I please?
Yes.
Due to non-payment of wages of workers, the Vakijai case was initiated against the owners of a tea estate, Nanlal Tea Industries, who later challenged the Vakijai proceedings itself by saying on the ground that the Assistant Labour Commissioner did not have the authority to initiate those proceedings. Meanwhile, in the auction proceedings that happened, Lord, we were the successful bidder. Lord, our bids were accepted, my lord, and sale certificates were issued in our favor. Entire payment was made in 2 installments, 25% and 75%. So, and finally, possession.
Your amount has not been
certificate-
refunded.
No amount has not been refunded at all
Okay. Okay. Amount has to be refunded by whom? By the state.
by the state, my lord.
And this thing was over when?
My lord, what had happened was
2020.
the learned single judge
No, the
Section-
Honorable Supreme Court order
Supreme
2020.
Order, my lord, is of 28th February 2020.
2020.
20th February 2020. Meanwhile, we had already started writing to them. We were also following up with them. In fact, the circle officer was also asked to
Okay, okay.
submit a report, my lord, status report.
You are Fukan.
My lord, A. Phukan.
A. Fukan. Part 3 A. Fukan Learned Counsel for the petitioners who is aggrieved by non-refund of the amount which was deposited as successful bidders pursuant to a Bakijai proceedings, full stop. It is submitted that the said proceeding was declared to be null and void and affirmed by the Honorable Supreme Court
My lord.
vide an order dated 28/2/2020, whereafter the petitioners had demanded refund of the amount which till now has not been done. Let notice be issued, returnable by, well, why are you late, Mr. Fukan?
My lord, we had been writing.
Writing
to
will not-
them, we
writing
were
will not be
following
enough.
up.
Writing will not be enough. You have a
we
good
were
cause of
following-
action, therefore we are issuing notice. Otherwise, this latches will come in your way.
No, I'll satisfy your lordship
um,
because we were writing to
Let
them.
notice be issued, returnable by 4 weeks.
For all the respondent, I must say.
Miss
120.
M. Borman, Learned State Council accepts for all the respondents extra copies.
Deeply obliged.
You purchased the property together or what? Separate purchase?
4, my lord, we purchased.
No, you are 4 of you are there.
We were 5, my lord.
5 of
us.
you are there.
Actually, the total that was auctioned was 31 bighas, out of which 10 bighas were purchased by the
No,
petitioners.
the question from the court is that this amount involves all 4 of you as a whole or separately?
My lord, it was one block. It was
No,
one
you had
block
4 of you purchased together.
together.
Okay.
Together, yes. Same dates, the sale certificates and the payment receipts, the possession
So was
certificates.
it a
also.
separate purchase or common purchase?
It was a common this thing. That whole block proceedings happened. It was a single proceeding. Obliged. my lord. Why not give a date, my lord, any convenient?
You tell us after 4 weeks? List on today is 12th, today is 12th. 1, 2, 3, 4. 9th is okay, 10th is okay for you?
My lord,
10th of September?
Yes, my lord.
10th September.
Deeply obliged.
No, 18, 19 are similar, my lord. Covered by lot of order, my lord.
Okay. Dispose of.
Deeply obliged, my lord.
Make the
And
correction.
Similar, my lord. My lord.
Next also.
Yes, my lord.
Okay, dispose of. Your name, K. Jain.
KJ.
K. Jain on behalf of SC Kyle. Huh?
Deeply obliged. lord.
Is Mr. Kyle around or not in the
No,
court?
no, it is in page 2.
Okay, K. Jain on behalf of SC Kyle.
Matter will be fixed at 2, my lord.
Hmm?
At 2.
At 2. If all the matters are over by 2, by 1 o'clock, then
Prior to 1, I will,
huh?
I'll
Before rising, you'll have to do.
try. my lord.
Why are you seeking adjournment? Kothakot is not around.
Lordship, he's in code number 10, item number 1 is going on.
What is the matter?
Well, the petitioner claims that the land is vizier land. My lord. Petitioner says that he is having pre-cultivation over the vizier land. And my lord, we have the circle officer has issued notice for eviction. He now challenges that the vizier lands, some other persons are also in the vizier land. You have not taken action against the others. And you have only chosen me to evict. That is one. And the second is that a policy was taken by the government to promote tea cultivation, small tea growers. He said that so I should be given settlement, in fact, in that land. That is his case.
But Vijay is not disputed.
VGR is not disputed. 11 Vigha land, VGR, and he has some Patta land also. In Patta land, we said that the mutation process is going on. We have no problem with that. Only in respect of 11 Vigha VGR land, we have sought
Okay,
to
let him
evict.
come then.
Lodge. Problem.
Wait, please, Lord. My lord, here in this case, a notice was issued to me, my lord, in respect of the scheduled land.
The other matter, Mr. Nath. Mr. Nath. This matter is of 16. We're not going to adjourn this matter.
Yes, sir.
We'll have it today.
Lord, I'm.
Ask him to come. 16 matter, we're not going to
No.
adjourn. Yes.
So, my lord, regarding scheduled land, my lord, I was given a notice that is at page 22, my lord.
Hmm.
The notice dated 9/5/2023. So I was directed to APR on 11/5/2023, page 22, my lord. So, my lord, accordingly, I appeared before the circle officer. But unfortunately, my lord, no hearing was done. Till date, no hearing is given, no next date is fixed. So thereafter, my lord, I filed a petition before the Deputy Commissioner Cooperative that I am in the land for long time, generation after. So land may be settled with me. That petition is pending till date, my lord. And what happened, my lord? After notice, the Joint Secretary, BTC is a party, the Joint Secretary BTC filed an affidavit. To that, my lord, we filed reply. But only grievance before your lordship is this. When I filed this application under settlement rules, my lord, under settlement rules 5. So when I file application before the Deputy Commissioner, it is the duty of the Deputy Commissioner to look into the matter and ultimately to dispose of the application under Rule 8 of the settlement rules. That is not done by the Deputy Commissioner. So, my lord, my humble submission before your lordship. First prayer is this, that land may be settled with me. Alternatively, I prayed before your lordship that this Deputy Commissioner may be directed to dispose of my application by a speaking order within a specified time with a copy to me, my lord. That's all. And in the meantime, my lord, till disposal of the petition, my lord, I may not be disturbed because, my lord, I am in the land for 77 years, generation after generation. My dwelling house is there,
You want an interim order in the final stage.
my lord. My lord.
Final hearing with an interim
No,
order.
no, my lord, regarding this.
No
disposal
interim
of-
order was passed in 2023. How can you pass an interim order in 2025?
My lord, no, my lord, my humble submission before your lordship, if alternative petition is allowed, my lord, the alternative prayer, if the Deputy Commissioner is to dispose of my petition, that order is not there. Till disposal, my lord,
From 23 to 25, you are still occupying.
yes, my lord.
Now, why do you need an interim order?
In that case, my lord, if your lordship
Yes, what do you
is
say?
not ready to dispose of, my lord, let the Deputy Commissioner file affidavit, my lord.
Land in question is now used by Salbari Weekly Bazaar Lordship. And Lordship petitioners and some other persons are illegally encroaching government land Lordship. Since land is transfer subject, Secretary has filed this affidavit that he is not entitled to the land.
That reason has also already
lord,
been disclosed.
Regarding this Salbari, my lord, Salbari weekly market, 10 bighas of land is there. Salbari weekly market is running without any objection from the government. If it is government khas land, my lord, Salbari market is running for 40 years. I am occupying the land from 77 years. Now government is saying that Salbari weekly market is going on. Weekly market did not raise any objection against me. It is the government raising objections. When khas land is used by Salbari weekly market, my position and Salbari weekly market is same.
Cannot be the same.
My lord, why
How
not?
can market?
Because, my lord, they are not
is,
settled with.
Market is catering to the
My
needs of the
humble submission
public.
before-
That
My
is
humble
public interest
submission
involved.
before your lordship. Why I am saying I am in equal position, same position, because, my lord, Salbari weekly market is not settled with. Salbari weekly market for 40 years running on government land. And I am running.
Where have you made this awareness?
77.
Where have you made this awareness that Salbari weekly market is not settled? Salbari is not even a party here.
Yes, my lord, Salbari is
Not even a
Salbari
party
is
here.
Party, my lord. Salbari weekly market is a private institution.
Where have you stated?
Maybe.
Maybe you will not do.
My lord, if necessary, my lord, I'll make them party.
No. And this is for admission hearing. There is no scope, further scope of
Your
change of
lordship.
pleadings.
My lord. Here, your lordship will take the affidavit in reply, my lord.
Your affidavit.
Yes, my lord. First, your lordship will take this affidavit in opposition. Page 37, my lord.
না ভুল হয়েছে 37 তো আমার
37.
37, my lord, page 37, affidavit in opposition.
Yes, please.
As second paragraph, said government khas land, so and so Shalbari is presently, Shaloni is presently used as Shalbari Weekly Bazaar with temporary shops. The petitioner's narrative in the petition states
credibility বলা spelling
that and cannot be reconciled with the facts on the ground. The claim that the land was wasteland covered by jungle is patently false. For 40 years, this land has been site of Shalbari Weekly Bazaar. So, my lord, my humble submission before your lordship, if it is not wasteland, how Shalbari Bazaar can run there? When Shalbari Bazaar is running on 10 bighas of land, my lord. I am in occupation of 2 bighas for a long time, 77 years.
Now you have to show some entitlement.
My lord,
You have to show some right.
my lord. So, my lord,
Now, when in the affidavit,
if
they have
government,
stated.
my lord, if the
Subsequent
government take a pick and choose policy, my lord. That to my lord, notice was given, I was not given hearing. And my representation is pending.
But
before the-
see thereafter, this act of encroachment occurred after the market's establishment or not
No, no,
before?
my lord, before.
No, that
before
is that is the statement.
That is their statement, my lord. I denied the same by filing my reply.
Let us see.
Your lordship would be pleased to run to page 42, my lord.
Hmm.
Third paragraph, my lord. That the land in question is khas land which is under possession of petitioner from pre-independence period. Though it is stated in the said paragraph that there is note of Shaloni in the Sita, but in fact there is not a single shal tree on the B settled land. So the stand is contradictory with the real fact. The deponent of affidavit in opposition through refer to Sita, but no Sita enclosed with the affidavit in opposition. So stand of the respondent number 5 is not supported by document and not sustainable. As the land is khas land, so mere noting that Shaloni will not change the nature of the land. The stand taken by the respondent number 5 that land in question is Shaloni and presently used by Shalbari Weekly Market is contradictory. Out of total land measuring 10 bigha, 1 kata 15 lesser, petitioner is in possession of 2 bighas of land. Said Shalbari Weekly Market is running without any hindrance over remaining portion of land. If petitioner encroached land of Shalbari Weekly Market, then the public and the market committee would have definitely opposed the same by filing objection before the concerned circle officer. Predecessor in interest of the petitioner were in occupation of the B schedule land since pre-independence period. After their death, petitioner is in occupation of said land. Shalbari Weekly Market is a newly constructed market. So, my lord, at this stage, my lord, my humble submission, let the deputy commissioner dispose of my representation as per law.
Lordship, here Saloni does not mean that salt trees were available.
We have read that. Does Saloni land means there has to be salt trees?
No, my lord, when it is said Shaloni, what for? Shaloni
No.
means there must be a salt tree.
No, no.
And another thing is this,
What is the
What
meaning?
does it mean, my lord, Saloni?
Yeah. What is the meaning of Saloni?
Saloni, yes, my lord. Saloni, my lord, in common parlance, my lord, what I understand, Saloni means there is shal tree, shal cultivation is there, shal tree is there. Now,
From
now,
where-
my,
from
now
where
your
do you-
lordship,
from
if
where do you
this
get this
is-
definition?
If this is Saloni, then how Salbari
where do you
weekly
get the
market is
definition?
running, that is their stand,
From where do you get the definition?
my lord. Definition, my lord, in the land revenue regulation, I have not found. Saloni. Saloni is generally written that there is shal trees.
No.
There is no definition, my lord. So far my knowledge, subject to correction by your lordship in the land revenue regulation. Saloni. I have not noticed, my lord.
Lordship proposal, they may
Mhm.
help us. If the proposal may help us, Saloni. Saloni means. Saloni বুলি কৈ যে এলেকাটো চালনি বুলি কৈ যে এৰিয়া এটা শাল খেতি থকাটো নুবুজায় অকল শাল গছ নহয় he has stated that area where trees were available but not only sal tree.
I think there is something. Okay, what is your stand, madam?
Lordship, my affidavit page 37, second paragraph, a portion of.
Here, I'm sorry to interfere. ma'am. Actually, main grievance against the deputy commissioner. Deputy commissioner, I filed the representation. Joint secretary BTC filed the affidavit in opposition. Here it is said regarding representation, he cannot say anything because representation was not filed before him. That is the stand. Regarding representation, my lord, reply comes like this. That representation I have not filed before the joint secretary or secretary. But deputy commissioner is to say, what about the representation? Deputy commissioner is not coming forward.
Since circle officer is under BTC lordship, revenue is transfer subject.
No, my lord, deputy commissioner is there. It is not, my lord, your lordship will consider. I am submitting, my lord, subject to correction because power of deputy commissioner under Assam land revenue regulation, settlement rules, whether taken away by BTC. That is not taken, but because, my lord, by the BTC Act, deputy commissioner's power under settlement rules framed under section 12 of the Assam land revenue regulation is not taken away. So I filed the representation as per settlement rules, my lord, under Rule 5. And your lordship, if I
The
file.
subject is the transfer subject or non-transfer
It's
subject?
not transfer subject, my lord. Let my learned friend clarify whether this land right, no, my lord, let me
Mr. Sheikh,
submit.
you are aware of it. There are 30 transfer subjects.
Yes, my lord.
It has been increased initially to 49. This is one of the transfer subjects.
Whether land.
But let us not go into.
Land matters is not taken away, my lord.
Let us not
That
go
is my
into
humble
that.
submission.
Let us
Let
not
them
go into.
clarify from this BTC Act, my lord. Whether land matter has been taken away. This is not taken away. That is why your lordship, always these BTC people demanding to the chief minister that you evict so and so person from encroachment. If they can do, they would have done it. Otherwise, chief minister would have said that no, BTC has the power. Land is transferred to them. Land matter is not transferred to them. So far my knowledge goes, my lord. Land matters is not transferred. Because patta is to be issued by the government.
Okay, yes,
So, my
madam.
lord, let the deputy commissioner, my lord, it is not the thing that BTC is created, so there is no deputy commissioner. There is a deputy commissioner functioning as deputy commissioner of Kokrajhar. I filed representation before the deputy commissioner Kokrajhar. Let the deputy commissioner Kokrajhar say That, no, I have no jurisdiction. I'm only looking into the law and order situation in Boroland. I'm not dealing with the land matters.
Okay.
Let him reply.
Mm.
Affidavit is necessary, my lord. He is a party.
This is the instruction from ADC, my lord, which indicates that land is a transferred subject.
Land is a transfer subject.
So
If he is,
making submission
he is-
doesn't give you any right of.
If he's insisting on making some submission, we cannot stop Mr. Sheikh. He's a senior person.
My lord.
That is why, my lord.
But it should make some sense, Mr. Sheikh.
My lord. No, my lord, I always submit before your lordship that subject to correction. Because, my lord, as per
That
BTC
is
Act.
why we are not saying anything. We are
BTC
allowing you
Act,
to
my lord,
complete your
BTC
submission.
Act, my lord, I have gone through BTC. My lord, what happened? Daily, government issuing notification, one after another. If the deputy
Let us not
if
digress
the
from the
deputy
issue.
commissioner come,
Let us not go beyond the issue. Let us be, there are many other cases.
my lord,
Other will take the whole day.
my lord,
You speak something,
my lord.
then see, then the court,
Yeah.
then we go to what the chief minister has said,
My lord.
then what the BTC had done.
My lord,
We are not on
I have
those.
very short
Well,
prayer.
let us deal the issue in
That
front.
the deputy
Yes.
commissioner will dispose my representation or let the deputy commissioner file an affidavit.
Yes, yes, madam.
It is not the case that deputy commissioner is not necessary party here.
Okay,
Page
yes.
37, second paragraph, a portion of this land is under illegal enforcement by several individuals, including the petitioner, Sri Nur Islam, and his two brothers.
Page
Who-
37.
Page 37, Lordship. Encroach upon 3 bigha 1 katha of Dag number 5, new,
Mr. Sheikh, have your seat, please.
Lordship.
Please have your seat.
My lord.
Further land measuring.
Just a minute, just a minute. See, you are not even landless, and in your rejoinder, you have not disputed. You have tried to bring in Article 111
Well, that is there.
of the limitation.
But, I'm
If you are not
I'm not
landless,
landless person, my lord.
if you are not landless, what is your entitlement for settlement?
My lord. No, my lord, your lordship,
There is no question of no.
my lord.
Unless you had made a statement that you are landless. The reply affidavit came that you are not landless. They have also given the
But,
DAC number.
My
There
reply
is no
is that
dispute. You have said
my-
yes.
My reply is this.
Though
my
the
lord.
petitioner have some parcel of patta
Not-
land,
not
but the
land.
authority is debarred from evict under Article 111 of the Limitation Act.
My lord. My lord. But that plea I have taken, my lord, because 77 years. The 30 years is the limit.
Yeah, anything else? Yes, Likhi. The present petition under Article 226 of the Constitution of India has been filed with the following relief, page 13 relief quote karjiye. As per the facts projected, there is a plot of land measuring 10 bigha, 1 katha, 15 lecha in village Kathalbari in the district of Kokrajhar. And out of the said plot, an area of 2 bighas was in the occupation of the grandfather of the petitioner since a long period of time. Full stop. It is projected that after the death of the grandfather, the father of the petitioner came in possession, and after his death, the petitioner is in possession of the said plot of land. Full stop. The circle officer, Bogribari Revenue Circle, had issued a notice dated 9/5/2023 to the petitioner, requiring him to appear before him, or otherwise he would be evicted. Full stop. It is contended that though the petitioner had appeared, no hearing had taken place, and accordingly, the petitioner had submitted an application dated 18/5/2023 for settlement of the B schedule land. Full stop. It is the case of the petitioner that the aforesaid application is pending and no reasoned order has been passed. Para. I have heard Sri M.A. Sheikh, learned counsel for the petitioner. I have also heard Miss R.B. Bora, learned standing counsel BTC, Miss M. Borman, learned state counsel, and Miss G. Hazarika, learned standing counsel revenue department. The Miss Boro, learned BTC, learned standing counsel BTC, has also submitted that the respondent number 5 has filed an affidavit in opposition on 13/2/2025. Para. Sri Sheikh, the learned counsel for the petitioner, has submitted that it is the deputy commissioner who is the competent authority to take a decision on the application for settlement, which has not been done. Full stop. He has emphasized that the possession of the land is with the petitioner since the days of his grandfather, and therefore a consideration is required to be made in accordance with law. He has also submitted that such consideration has to be fairly made and there cannot be any discrimination. Para. Ms. Bora, the learned standing counsel, BTC, has however submitted that the petitioner is an encroacher of government khas land. Full stop. By drawing the attention of this court to the affidavit in opposition filed by the respondent number 5 on 13/2/2025, more particularly the averments made in paragraph 4 thereof, the learned standing counsel has submitted that the land in question is government khas land bearing DAG number 5 within bracket new /4 within bracket old and is recorded as Saloni within inverted comma SALONI, page 37 देख लीजिए, and is presently used as the Salbari Weekly Bazaar in a temporary basis. Full stop. It has been clearly mentioned that the land is under illegal encroachment by several individuals, including the petitioner and his brothers. Full stop. It is Further it is also averred that a plot that land measuring 1 katha 5 lechas, which belongs to the office of the circle officer Bogribari, is also under illegal encroachment of the petitioner by way of cultivation. It has also been stated that the petitioner and his brothers are not landless, and rather they own patta land, the description of which is also mentioned. Full stop. She has submitted that under such circumstances, the scope of considering an application for settlement of the land in question is absolutely not there. Para. In his rejoinder, the learned counsel for the petitioner has submitted that if the Salbari weekly bazaar is allowed to function from the plot of land, the petitioner has also got a right to be considered for settlement of the land in question, as there cannot be any discrimination. Full stop. Para. The rival submissions have been duly considered, and the materials placed before this court have been carefully perused. Para. The issue is with regard to the claim for allotment of a plot of land for which allotment is settlement, for which the petitioner claims to have made an application on 18/5/2023. Full stop. The aforesaid application has been submitted after a notice dated 9/5/2023 issued by the circle officer. Full stop. Though it appears that the notice could not be brought to a logical conclusion, the land in question is government khas land, which is not disputed. Full stop. What is also of relevance is that there is a clear averment made in the affidavit in opposition that the petitioner is not landless. Full stop. While in the rejoinder affidavit filed by the petitioner on 21/3/2025, the other averments have been sought to be refuted. The averment made by the respondent that the petitioner and his brothers are not landless is not refuted, is not disputed, and rather the petitioner has tried to take resort to Article 111 of the Limitation Act 1963. Full stop. For ready reference, the relevant averments made in the affidavit in opposition and the rejoinder affidavit are extracted here in below. Para. As regards the submission made that the subject involved is not one of the transferred subject, this court is unable to accept the said submission as the subject land is one of the transferred subjects. Full stop. In this regard, Ms. Burman, the learned State Counsel, has also placed on record a written instruction dated 7 May 2025, wherein it has been clearly stated that after creation of the BTC, the land matter is transferred to the BTC. Para. Be that as it may, the consideration of the application filed by the petitioner on 18/5/2023 has to be examined on the background facts and circumstances, full stop. As discussed above, comma, there is a clear 10 of the respondent that the petitioner is an encroacher of government land. And what is also more important is that the petitioner is not a landless person. Sarah? In view of the above, comma, this court is of a considered opinion that no relief is entitled to by the petitioner. Full stop. The petition accordingly stands dismissed.
May I pray that a copy of the notification, may I correct it,
Which one?
is supplied to your lordship.
It is there in public domain, take it out.
My learned friend can supply one copy to me, ma'am.
Next.
It is there, the notification is there, you take it out, it's there and available.
Well, not only
49 subject.
your lordship mentioned the date of the notification, but number is not mentioned. If number is.
That is not the date of notification. We have mentioned the date of the communication.
So only.
It's a letter.
Still coming.
A copy may be supplied to me,
That is up to your friend.
my lord.
Petition authority.
Yes, next.
একটা copy দিব পারিব না।
Lordship, Mr. Nath is on Lakes on Court
Yes, sir.
12.
Ask him to come, 16 matter.
My lord.
Wait for a while.
Or little accommodation, my lord, he's doing.
তাতে দেখলে ফটো দিলে
Madam, please tell Mr. Bothakur when he should come. He may be having some other cases.
My lord, he's in Court 12.
When he should come, give him a date, a
Just
time.
matter has started, he said that he will just come, my lord.
Okay,
After doing that matter, I will inform.
okay, next. 2 and 3. 3. Ayat Alugdar. Yes, Mr. Alugdar?
Your lordship, my lord, regarding the.
Private respondents are there today.
Yes, my lord.
You are for the private respondent. Okay, very good. What is the matter about?
My matter is regarding election of the Udali Samobhaya Samiti Limited. Election was.
You were elected.
Yes.
You were elected, then it was cancelled.
It was disapproved by the Register of the Cooperative Society. Not cancelled, man. Election was disapproved as per order 24-1, my lord.
I think we heard this matter for some
Yes,
time.
it's first of August.
Asan
My
ki
lord.
note asan ki amma?
Operative part is, my lord, page 49,
Just a minute, please.
annexure 9, page 48. It was heard by your lordship on 1st August.
No. You have to narrate the facts again. We don't have any notes.
My lord,
What has happened? Tell us.
my lord, election was held on 23/9/2023.
23/9/23.
23, Udali Samobhaya Samiti Limited. My lord, winning candidate to election result was given on 25/9/2000.
Just a minute, please. Odali is in
Udali
Hujai,
Samobhaya-
Hujai.
Yes, Udali Samobhaya Samiti Limited in the district of Hujai.
Elections were held on 23/9/23.
Yes, my lord. Counting started on 25/9/2023.
Okay.
The result was also given on 25/9/2023. It
Yes.
as per the inquiry officer report, my lord, she has stated in the inquiry reply,
What happened in the results?
the result elected, the petitioners were declared elected.
Petitioners elected.
Elected.
You were 8.
Yes, up from 1 to 8.
You are 8 numbers of petition.
Yeah, 8 number of petitioners.
You're elected. Thereafter,
17, another 7 number of candidates are there. They are not in the present case.
okay.
The only opposition came from the respondent number 6 and 7. They were not elected. My lord, they have filed an application for recounting of votes. It was on 26/9/2023, after the election declaration was given, after the winning certificate was issued.
Oh, the other day we asked you.
Yes,
Whether you had the party or not. You said this party was also done.
yes. So what did happen?
Winning candidate.
This,
But you said it was early in the morning, 4 o'clock.
my lord,
4 o'clock in the
yes, my
morning.
lord,
We remember.
3 hours,
Wee hours.
3 hours,
4 o'clock.
4 o'clock.
4 o'clock, the sweet shops were all closed.
My lord, this is the error committed by the, in lieu of 26, the officer concerned has written 25. This is the only mistake. Entire petition is only this small mistake. Then what had happened, my lord? After this recounting was application submitted, then the Register of Cooperative Societies has issued Affairs Annexure 4, page 37. To submit the report regarding election and counting of process.
Page,
Page, my lord, 37.
37.
Yes.
Yes, please.
To submit, I am request you to submit a detailed report regarding the last line, my lord, regarding election and counting process with documentary evidence regarding videography still photos, if any, within 7 days from the date of issue of this order. It was given to returning officer by the registrar.
Assistant Register.
Yes. Returning officer. Assistant registrar issued letter to returning officer. Election returning officer.
What is the direction?
Thereafter, my lord.
What is the direction to make a detailed inquiry?
Detailed inquiry report.
Yes.
Thereafter, my lord, on 6/10/2023, they filed an appeal before the Register of Cooperative Societies under section 111 of the Cooperative.
Who had filed?
This respondent number 6 and 7.
No, this inquiry was already ordered.
Inquiry was already ordered. In the meantime, my lord, they have filed an appeal before the Register of Cooperative Societies.
When was appeal filed?
6/10/2023.
6/10/23. Appeal by R4 and R6 and 7.
6 and 7. R6 and 7.
Before? Before whom?
Before the Register of Cooperative Societies.
Yes. Then?
Thereafter, what had happened, my lord? They have filed the Annexure 6, my lord, page 41, regarding recountings of votes.
That page 38 is the 638.
41, page 41.
Yes.
Regarding recountings of vote, the Assistant Register of Cooperative Society written a letter to respondent number 6 and 7.
They rejected.
Yes,
Rejected?
on the ground that since you have not deposited the scrutiny fees
Yes.
as per law which is required for recounting within the statutory period, within the period of time, so your prayer was rejected. This is done on 6th October. For recounting, fees is required to be paid within 3 days, but they have not paid.
Just a minute, please. Yes,
Thereafter, my lord, these petitioners filed writ petition before this honorable High Court. Writ petition number 6206/2023, and the same was
6-2,
6206/2023.
you had filed.
My lord, respondent number 6 and 7 filed.
Oh, the R6 and 7 filed.
Yes, my lord.
Yes, what was the,
The Honorable High Court dismissed the writ petition, directing that since the appeal is pending before the Registrar of Cooperative Society, so this writ petition is not tenable in the eye of law.
you are referring to the order dated 10,
10,
11,
23,
10,
my lord.
11.
Yes, page 47.
Yes,
Now, my lord, Registrar of Cooperative Societies, after receiving the complaint from the respondent number 6 and 7, issue notice to the present petitioners. And the present petitioner appeared there before the,
in the appeal.
yeah, in the appeal. And the Registrar of Cooperative heard the parties, and on 24/1/2024 dispose of this appeal, my lord.
Page 48.
Page 48, my lord. In operative part is page 49. My lord, if your lordship kindly have a look, page 48, last part, since from the word since. Since both the parties did not agree to recounting, as it is evident from the report of Superintendent of Police, as well as on the perusal of documents, that the AGM election was not held as per law. It is seen that the counting was completed on date 26/9/2023 at 3:52 a.m. But the result was signed on 25/9 by mistake. This is the mistake, only this error. No other error has been found. In view of above and in consideration of all aspects, I, Sri Narayan Konwar, IS, Registrar of Cooperative Societies, is of the opinion that the AGM election was not held as per the Assam Cooperative Societies and Assam Cooperative Societies Election Rule 2019. There was no substantive evidence produced before the Registrar of Cooperative Societies. The AGM was not held according to the law, or if any anomalies or anything took place, nothing was produced. He hereby directed to appoint one man and management to the said societies to hold the AGM within 90 days from the date of this issue of this order. Moreover, Sri Hiru Mohanto, Inspector of Auditor, Cooperative Society Returning Officer, is hereby asked to so cause his reply as to why the ballot box handled as per the procedure, not as handled as per the procedure mentioned in the Assam Cooperative Societies. This so cause was issued to the returning officer, my lord, and the returning officer has submitted his so cause reply. I have collected it through my petitioner has collected through RTI. Now, inquiry report is, my lord, kindly have a look. Inquiry report, page 73. My lord, operative part is, important part is page 74 middle. However,
Just a minute, please.
74,
70.
74, my lord. 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 74, my lord.
24.
Mode. However, it is mentioned that counting of the votes was carried out in 2 rooms in presence of the candidates or their authorized agents by the assistant returning officer supervisor under my supervision. And the result too was announced and or declared just on counting of the vote by 3:20 AM. But by mistake, as a human nature, I put the date on 25/9/2023 instead of 26/9/2023. That is the only mistake which was disclosed by the returning officer. And he should not be, I may not be penalized. This is the main crux of this issue. Now, what wrong the petitioner has committed? This to be decided by your lordship for the ends of justice. Nothing was produced before the register. Even respondent authorities in their affidavit in opposition, nothing was produced. How this election recounting will be held, how this election will not be approved, this will not be approved. That is my humble prayer before your lords.
Are you citing any case clause?
My lord, I am not citing because exactly such case I could not correct my name. I tried my level best again.
On the principle
My lord,
of human error,
regarding him, I unable to find out my lord. Regarding law point, I tried, but it was not available.
yes, Mr. Taludar, now presently it's been run by a one-man committee.
My lord, my first submission is that your lordship is aware that if a quasi-judicial order or an administrative order, it contains, my lord, more than one grounds. Even if one ground vitiates, my lord, the other ground can sustain, my lord, the order. My lord, this is not the only ground. My lord, we have stated, if your lordship takes up, my lord, the affidavit in opposition, it starts, my lord, from page 45. I draw your lordship's attention, my lord, to 2-3 paragraphs, why the order has been passed, my lord. I draw your lordship's attention to page 47 of my affidavit in opposition.
47.
My lord, page 47. The affidavit in opposition starts from 45. I take your lordships to page 47 from clause 3 of para 4, my lord.
47, I think you are referring to the affidavit in opposition.
By the register, my lord, yes.
That
It
is
starts
not
from page 45, my lord, if I am not mistaken. It was the writ petition, my lord. Oh, sorry, my lord, it should start from page 50, my lord. Writ petition ends, my lord, at page 49.
That is what we are saying.
50, 51, 52, my lord, page 52. Clause 3 of para 4. May I read it, my lord? Clause 3 of para 4.
Para
4. Para 4, clause 3, my lord. Or sub para 3, my lord.
What is your name? You are not Sirazul Haq.
No.
50 starts is their affidavit.
Uh-huh.
Not 50. 50 is their affidavit. Your has come after that. You're Binod Kumar Agarwal.
Yes, my lord.
Your starts at 58.
Sorry.
58 started from 58.
Sorry. 58. 59.
That's one number 2.
My lord.
Clause?
My lord, sub para 3, my lord, or para 4. May I read it, my lord?
Just a minute.
My lord.
Yes.
That section 2U of rules, it should be rule, my lord. Rule 2U of rules of 2019 defines a strong room as follows. Strong room means the nearest police station, outpost, or the treasury office of the district subdivision concerned. In view of the said definition of strong room, the returning officer had no occasion to keep the used ballot box in a guest house instead of either in the nearest police station, police outpost, or the concerned treasury office. The aforesaid conduct of the returning officer cannot be accepted to be a bona fide mistake, and the same gives rise to a strong inference of malice on his part. Being the returning officer, he is expected to be aware of the mandate of the rules of 2019 as well as the procedure embodied therein. Number 4, subpara 4, that the complaint as well as the representations received from the aggrieved parties invariably go to show that during the counting process, objections were raised in respect of the correctness of the counting of votes and marking thereof to the respective candidates. It further appears that counting of votes also got to be disrupted due to frequent disturbance of electricity supply. Under such circumstances, the returning officer ought to have been more responsible for preservation of the used ballot box in accordance with the mandate of rule of 2019. That being the para 5, subpara 5, that being the election authority in terms of the rules of 2019, it is incumbent on him to see, while proceeding to decide the legality or otherwise of an election process under Rule 27 of the said rules of 2019, that the election for its all practical purposes is fair and transparent. Under the present facts, as an election authority, the respondent number 2, having found that keeping the ballot papers in a guest house by the returning officer contaminates the sanctity of the election process, he proposed for recounting of the votes for the purpose of a fair and transparent election. It is needless to say the petitioners herein disagreed in respect of such a proposition, and thereby the election authority had no other option but to cancel the election. That under Rule 27 of the election rules of 2019, the election authority possesses wide and extensive power, enabling him to pass any necessary order which he deems fit and appropriate upon making an inquiry in respect of the election dispute. In the present case, the election authority having found that in absence of recounting of votes, the result of the election stands vitiated on account of the conduct of the returning officer keeping the used ballot papers in a wrongful manner, not sanctioned by law, and in view of the complaint raised by the aggrieved parties during the course of the counting as well as upon declaration of result of the election AGM in question. Under such circumstances, in absence of recounting of votes, to maintain a fair election, the alternative course of action was to set aside the election as had been done by issuing the impugn order, directing the returning officer to show cause as to why he had violated the mandate of law and holding of election within 90 days from the date of passing of the said order 24/1/24. So basically, my lord, this is one of the ground. And during the counting, there were objections raised. And subsequently also, my lord, complaint, appeal has been filed. And your lordship will kindly see, my lord, it is not the ARCS or the returning officer who is the election authority. Election authority is defined under the rules. It is only the registrar who can decide the correctness or otherwise of the election, my lord, held, my lord. So therefore, even an inquiry was directed by the ARCS, is incompetent to do, my lord, on completion of the election, my lord. That inquiry holds, my lord, no water, even if that was done in favor of the petitioners, my lord. So it is only the registrar who is empowered under Rule 27 to pass appropriate orders. So therefore, my lord, the election authority found it proper to cancel the election to maintain its sanctity, my lord. So this is, my lord, my respectful submission. So this is the primary ground on which, my lord, it has been cancelled, because your lordship will find that has been reflected, my lord, in the impugn order. Page 48, my lord, last part. And before that, my lord, I take your lordships to the third paragraph from the, my lord, bottom. The SP Hujai stated in his report that as informed by the police officials on...
You have read this? Sarada Guest House.
Yes, my lord.
You have read this?
Yes, and lordship will kindly see the last part of the impugn order. Since both the parties did not agree to recounting, and it is evident from the report of the superintendent of police, Hujai, as well as on perusal of documents, that the election AGM was not held as per law. So they did not agree, my lord, for the recounting. And in absence of that, my lord, there was a doubt in the election, my lord, authority that, my lord, the election process, my lord, stands contaminated and stands vitiated. So this is one of the ground. So mistake, my lord, my humble submission may be the other ground, but if this ground sustains, my lord, then the interim order would, my lord, prevail. The impugn order would prevail.
My lord, may I
Yes, let him finish.
may I clarify the stand taken by my...
Let him finish.
Yes.
My lord, your lordship will see from the impugn order, there are other complainants also from paragraph 7 of the impugn order, Kamal Chaudhary and others, my lord, they are not made party respondent. They would also, my lord, they might have also, my lord, something to say. Page 48, impugn order, Kamal Haq Chaudhary and others. And this, my lord, complaint submitted by them has also been taken into consideration by the election authority. They are not before your lordship, my lord. So on the ground of, my lord, want of necessary party, this writ petition is not maintainable. Their grievance, my lord, they are not able to place before your lordships. Another complaint petition was also submitted by Kamrul Haq Chaudhary, second paragraph, my lord, and others stating the irregularities taken place during the conduct of election of so and so.
Now, this order was passed in the year 2024 January.
My lord.
Is there any indication in this order regarding holding of fresh elections?
Yes.
Where?
My lord, once the election AGM is disapproved, and once the, my lord, the one-man committee is appointed under 41(6), your lordship will kindly see 41(6), my lord. Because
No,
this
we are
orders-
not on the provisions of law. Is there an indication in this order
My lord.
regarding the impending fresh election?
Yes, lordship will kindly see. My lord, I am
Please,
reading the last part of the order.
Yes, 49.
Yes, my lord, 49. In
Yes.
view of above and in consideration of all aspects, I so and so is the opinion of the AGM election not held as per Assam Cooperative Societies Act so and so and liable to be disapproved. The Zonal Joint Register of Cooperative Societies is hereby directed to appoint one-man management to say the societies to hold the AGM within 90 days from the date of issue of this order. So therefore, AGM election within 90 days under 41(6), my lord. And Zonal Register passes the order under 41(6). Therefore, he directed him to pass the order. And thereafter, the one-man committee is, my lord, appointed. If your lordship says 41(6), my lord, for the time being,
Yes, it's not.
for a moment, my lord.
Super. Puro kitab apni. You are referring to?
41(6), my lord.
Page 38.
Because this power is exercised under 41(6), my lord. And the this power is delegated, my lord, to the zonal register by notification of the government, my lord. Where a board fails to arrange for holding election before the expiry of the term of the board or delegates, or where there are no directors remaining on the board, the register shall convene a general meeting by appointing an officer of the cooperative department for constitution of the board within 90 days. Your lordship will see.
No, this is on a different contemplation. If the board fails,
Yes.
what is the provision in law that if the election is declared to be bad in law,
Yes.
then which provision will be there?
No, my lord, lordship is absolutely correct. In fact, when the, my lord, AGM election is disapproved,
Yes.
then, my lord, it is constituted, my lord, that the board has failed. Because other provisions, my lord, there are no other
No,
provisions.
your submission has to be supported by some. Cannot just say that failing to arrange for holding the election
Yes.
and holding an election which has been declared to be bad.
Yes.
These are two different, absolutely different
Lordship is
things.
absolutely correct.
But if there is anything
Yes.
to construe or read in the proviso, the subsection 6 in a situation of this nature,
Yes.
kindly show before us.
My lord, yes, lordship is correct. My lord, there are no other provisions. But when, my lord, the election authority set aside the election or disapproves, my lord, the resolution, then, my lord, invariably, there is, my lord, no other option but to hold the election. There is, my lord, there is no other alternative, my lord. Election has to be held. One, it is cancelled, my lord, by the election authority. And it is here.
But this direction
Yes.
to hold the AGM within 90 days, it may not be under 41(6).
Yes.
May not be under
No,
41(6).
my lord. My
If
lord,
the election goes, fresh elections are required to be held.
yes.
But 41(6) is on a different context altogether.
Lordship is correct. My lord, the contemplation of the, my lord, 41(6) is a one-man committee, my lord, cannot, my lord, continue for an indefinite period. So therefore, the statute, my lord, has prescribed a time limit, my lord, 90 days. And within this 90
No,
days,
the registrar may borrow part of subsection 6
my lord,
that in the interregnum, one-man committee would run and he would hold the AGM within 90 days.
yes, my lord.
But the preceding condition that failing to arrange for holding a meeting, holding election, this is not the case.
Lordship is absolutely correct, my lord. Under such situation, my lord, there is no other provision under the Act. So while, my lord, disapproving, cancelling, whatsoever, my lord, when, my lord, the board is dissolved, new board is not constituted, the one-man committee comes in and he has to hold the
This
election.
appeal, this order has been passed under what provisions of law? The appellate order?
No such narration.
My lord, this order, my lord, we have stated that it has to be constituted to be a, my lord, election petition under Rule 27. If your lordship comes to Rule 27 of the election rules, is the election authority redressal of dispute?
Page 120.
Of the book. Rule 27 reads, my lord, as follows: redressal of dispute. Any dispute relating to election of a cooperative society may be submitted within 3 days from the date of declaration of the results before the election authority. Now, election authority is defined, my lord, under section 2F. It is the registrar, my lord. And B, my lord, the election authority shall make an inquiry upon the dispute on the basis of the relevant records and pass necessary orders. So, my lord, this my lord, power under Rule 27 has to be understood to be wide and extensive. To pass any order, pass necessary order under the facts and circumstances.
Where is the appeal?
My lord,
Is it there on record?
yes, they have submitted the appeal. It is,
I think page 38.
yes, first one is page, my lord,
38.
35, my lord.
35.
Yes,
38.
page,
610.
38.
38. So
38.
610 to the 23. First
No.
appeal.
No.
Appeal.
My lord, the complaints and representation starts from page 33, my lord.
It is to assistant registrar of property.
Yes, well, this can be taken care of by the election authority, my lord.
No, if the election authority has been defined under 2F,
My lord.
Yes.
it has to be addressed to the election authority. That is the, at 610,
No, election
at
authority
page
has,
38.
election authority has taken, my lord, into consideration this, my lord, representation also, 27-9. Though it is, my lord, addressed to the assistant registrar.
No,
Because
if it-
this is
that,
the-
that cannot be construed to be a dispute. If you are on the one hand, you are emphasizing that whose authority is there, it is the registrar,
Yes,
not the assistant registrar.
my lord.
Then we have to see which is the appeal which was filed before the election authority,
My lord.
which we find at page 38. What is the take of the authority on the period of 6 days, 3 days?
My lord, if here my
My-
lord, language, if your lordship comes to the language of
Yes,
rule
yes.
27,
Yes.
Rule 24, my lord. Rule 24, recounting of votes.
Just a
That-
minute, let him submit, we'll
Yeah,
come to
yes.
you. We are not, we'll hear you, don't worry.
my lord will kindly see rule 27. Any dispute relating to election of a cooperative society may be submitted.
Hmm.
So therefore, my lord, the limitation of 3 days, my lord, is not, my lord, inflexible. It is not mandatory, my lord. May submit within 3 daes, my lord.
Where are you reading?
Rule 27A, my lord.
A.
Yes, it is not in my respectful submission, it is not inflexible.
Within 3
Any
days.
dispute relating to election of a cooperative society may be submitted within 3 days from the date of declaration of the result. So it has to be constitute, my lord, to be not inflexible.
Then is there any,
It is
discuss-
directory.
is there any discussion
Which one, my
in
lord?
the order that irrespective of the fact,
No.
in spite of the fact that it
No.
is not filed within 3 days,
Yes.
but still then I think
No,
it's
there
a
is no
justified
there
cause.
is no discussion. It is apparent from the order.
No, we may accept your submission that
Yes.
that is not mandatory.
Yes.
But if 3 days is prescribed,
My lord.
you have to make at least one reason that this has been done after 3 days, but I find good
That-
enough
correct.
reasons to go ahead.
That is correct.
Otherwise, there is no requirement to put 3 days.
That is correct.
Yeah, anywhere, please see in the order, anywhere in the order.
My lord, in 4.1, my lord, we have clarified, para 4, subpara 1, page 59, this part of the, my lord, your lordship's query.
59.
Yes, page 59. Paragraph 4, subpara 1.
Yes, please.
That the order dated 24/1/24 adjudicating the correctness of the election AGM of orderly GPSs, though having been passed on the appeal petition by the aggrieved parties. However, the complaint petition filed by one Sirajul Haq Borbhuya on 27/9/23, immediately on conclusion of the AGM election in question, also having been taken into consideration, the impugned order dated so and so has to be understood to be an order passed under Rule 27. So this is clarified here, madam.
Now, where is the time period? 27/9. The impugned order is date, what is the date of the impugned order?
Impugned order, my lord, is dated
24.
24/1.
My lord.
When is the appeal?
6/10,
6/10. And if you go to the complaint, that is of 27/9.
Yes.
It even makes your case worse.
The election was held on, my lord, 23/9.
23, the declaration of results were in 25/26.
Yes, within that. So therefore, my lord, it is within time, 27. 27.
But 27 was not 27/9, it was not addressed to him.
That is correct, my lord. But this was taken into consideration.
Let us see 27/10.
27?
27/9, the complaint.
Yes. My lord, the vernacular is at page, my lord, 35. And
30?
the type copy, my lord, it starts at page 33.
33.
My lord.
Three. Yes. Come election authority.
Yes.
Let us see the vernacular.
Yes, that would be, my lord, more.
মাননীয় সহকারী পঞ্জীয়ক মহোদয়ত তথা নির্বাচনী অধিকারী
সম্মানপূর্বক বিনীত নিবেদন।
who is the complainant?
The complainant, my lord, are the same, my lord, Sirajul Haq and Zakir Hussain Chaudhary, who had subsequently, my lord, filed the appeal before the registrar. So at the initial point of time, they had made. সম্মানপূৰ্বক নিবেদন এই যে উদালি সমবায় সমিতি লিমিটেড যোৱা ইমান তাৰিখে হৈ যোৱা সমিতিৰ সঞ্চালক মন্ডলী নিৰ্বাচনৰ ভোটদান প্ৰক্ৰিয়া সমাপ্তি পিছত 25/9/23 ইংৰাজী তাৰিখে হোৱা ভোট গণনা প্ৰক্ৰিয়াত বহুতো বিসংগতি দেখিব পোৱা যায়। মহোদয়, ভোট গণনা প্ৰক্ৰিয়া চলি থকা অৱস্থাত
That we have seen, that we have read.
Right.
27/9. that proceeding ended, you cannot improve in your affidavit. If you come to page, first you have read 33, okay?
Yes, sir.
33 is the English translated copy.
That is,
Then you come to 37.
yes.
It was addressed to the Eastern Register of Cooperative Societies. It was considered by the Eastern Register of Cooperative at page 37. And kindly come to the reference part. This is the complaint 27.9. Have you got, Mr. Aludar?
Yes.
Reference
27.
27.9.
Yes,
You come to page 37.
37, yes.
This reference is of 27.9.
Yes.
The complaint
Yes,
after the subject. Have you got it?
yes.
27.9. Then you kindly turn over to page 41. We are not on the reasons that fees not paid those, but this has been acted upon. This is a different channel. Whether it was a proper channel or not, we cannot know. Now you cannot say that no, we consider this also to be a complaint, which was not even addressed to you.
No, that I leave it to Lordship, my lord, but your
No, that
Lordship
you
will
cannot
say-
improve. That is the
No,
question
but-
of law. If you
No,
you are aware.
what I'm trying to say, Assistant Registrar, my lord, apparently, under the rules, my lord, did not have any authority. He did not, my lord, he was
So
not.
that petition will have no meaning. How do you say in the affidavit that we have also considered 27.9? It is not even addressed to you. Your submission has to be consistent. At one time you disown the assistant registrar that he is not the authority. But it was addressed to him. He had taken some steps. Let us assume that those steps
My lord,
were taken without any authority.
My lord will see from 37,
Yes.
that finding reference of 27.9.
Mm.
My lord, those copies are also, my lord, sent to the registrar. The registrar, my lord, had these, my lord, materials before him while passing the impugn order.
In the last stage.
My lord, this is my submission, my lord, lots correct, subject to correction, my lord. But while considering the, my lord, the grievances, my lord, all these materials were considered by the registrar.
Where is the copy marked to the registrar? 27.9.
No, 27, no, my lord.
Copy marked to the registrar.
37, my lord. If you lot,
That is the response by the Eastern Registrar.
yes.
The registrar does not have the jurisdiction. He does not come into the play. The appellate authority comes into play only after 6:10. And he has not made even a single whisper with regard to the time.
Your lordship will see, my lord, page 37.
37.
Reference, my lord, is complaint petition from so-and-so.
Hmm.
And after passing this order, my lord, he had forwarded, my lord, the order, complaint petition, etc. to the registrar also, my lord. Page 37, it will appear. So while passing the impugn order,
Where?
page 37.
Yes, 37. Yes.
The reference, my lord, of complaint petition from so-and-so.
Yes.
And thereafter, my lord, he perhaps made some inquiry and whatsoever.
No,
Then
this is some action taken by the Eastern Register. Whether he was authorized to or not, that's a different
yes,
aspect.
what
of
I'm
the
trying
matter.
to say, while passing the impugn order subsequently, the registrar, my lord, had this material before him. So whether or not, my lord, he
It
could
cannot
have
be
considered.
construed. It cannot be construed. If he had done so, it has to be reflected in the order itself. At least one expression, one word. Please read the
And
impugned
your
order.
lordship will
Please
kindly
read the
see-
impugned order if
Yes,
there is anything
leaving,
else.
my lord, leaving aside this particular complaint, if your lordship comes to the page 48, that another complaint is also mentioned there,
Yes.
my lord.
That is what, 25.9.
That is, my lord, not on record, not placed by.
25.9.
Yes,
Hmm.
and they are not made parties also. My lord.
25.9. Yes, anything else?
This is my humble submission, my lord.
Yes,
So therefore, the only ground, my lord, is not a mistake. The other ground, if survives, my lord, then the same does not vitiate the impugn order. This settled proportion of law, lordship is aware, my lord.
Yes, what is your name?
Is thus.
Each does.
Yes, ma'am.
Here for,
For respondent number 6 and 7. We
you have filed a affidavit.
Yes, madam, we have filed a proof.
Just a minute.
We have,
please.
from page number 50 onward.
Just a minute, please. Affidavit in opposition, 6 and 7.
Yes.
Yes, page 50 onwards, correct.
Yes. We have objected the counting process during the counting was going on. And that was not considered at that time. And later on, before the register also, we have filed on petition. Second last paragraph, page number 48, annexure 9.
Page number?
Page number 48, annexure 9, last second para.
Yes.
There, para started, therefore, there is every possibilities that the ballots have been tampered with during the course of the hearing. It was stated to both the petitioner and respondent that recounting of ballots as stated in the petition would be allowed if both parties agreed to it in writing. Further, Cizarul Haq, Borbhuya and Zakir Hussain Chaudhary, that is the private respondent number 6 and 7, submitted a petition requesting the recounting of votes, and on the other hand, Abdul Hasib and 7 others, that is the petitioner, present petitioner, submitted another petition in opposing the recounting of votes, my lord. Well, even before register, we have shown our interest for recounting, because while counting was going on, we have seen some irregularities. That's why we have objected the whole process, my lord. But the recounting was objected by the present petitioner. Reason best known for them, Your Honor. And since
No, you kindly read again.
yes,
Therefore, there is every possibilities that the ballots have been tampered during the course of hearing.
Huh.
It was stated to both the petitioners
and
and the respondents. Petitioners were you, respondents are the
yes, madam.
Mr. Taluda's client.
Yes, madam.
That recounting of the ballots as stated in the petition would be allowed
Yes,
if both parties agreed to it in writing.
yes,
Then there was no agreement.
yes, madam.
So it
But
was only at the
yes-
stage of hearing,
Yes.
not at the time of counting. It is time of hearing. So what is your take on the aspect that the appeal was not filed within the period of 3 days? And if you do not do, can the appeal still be considered? Or is it a mandatory?
Immediately we have lost complaint before the election officer, and after that we are laymen, but because we are not aware about the.
There is a layman will not work out.
Yes,
There
ma'am.
is a prescription of law which
Yes.
prescribes
But we have
that an
immediately.
appeal has to be filed before the election authority.
Yes, ma'am.
Election authority has been defined under 2F.
Yes.
You somehow had gone to the ARCS. ARCS has also taken some action and rejected your petition not on merits, but on the aspect that you did not deposit the fee required.
So far that fee, but we have not informed that we have to deposit the fee order.
Now that authority, that ARCS perhaps was not is not the authority
Yes.
who could have done something. What is the term of 5 years?
5 years.
Now these elections were held in 2023.
Yes, sir.
2 years already gone. Yes, anything else, Mr. Das?
No, ma'am.
Hmm?
But there is some.
What was the margin? Margin votes? Any
Margin,
idea?
It was not disclosed, my lord.
Undisclosed. Then how did you know that you have won the elections?
It was not in written because it was election result already given, my lord. And margin would have, it was not given to me. There's no
If the
certificate,
results
documentary,
were
no,
declared. then
no documentary evidence was given to me, except certificate annexure 1, my lord.
Where? Page?
My lord, page 1,
Annexure-
page, my lord, annexure 2, my lord, series, page 23.
23. You secured 814 votes.
Yes, this is vote 814.
800, you know your votes. How much vote did the second candidate get?
96,
Huh?
so 8 candidates are there.
No, the opponents.
There was not disclosed.
Where is the signature of 25-9, Mr. Taluda? That human error, do you have the record? I mean the paper where. We'll come back to you, Mr. Das, if you have got anything more to say. Do you have anything more to say?
No. My lord, you have not. I have given in my affidavit reply. Page 76, my lord.
$76.
Yes, my lord.
What is it?
This is this Hiru Mohanto, returning officer, who has stated that it is a human error.
No, we are not on that. We are not on the so-called reply.
Yes.
We are on the aspect, which is the document,
Yeah.
where he had put his signature, followed by the date as 25-9 instead of 26-9. That document is there.
That this is not on record, man.
Because the impugned order.
Yes.
At page 48, last line,
Yes.
since both the parties did not agree to recounting, it is evident from the report of the super, as well as the documents had as follows. It is seen that the counting was completed on date 26-9 at 3:52 AM. But the result sheet was signed on, where, do you have the result sheet?
I'm trying to find out, man.
Result sheet.
Oh, apne bahut. He's excited, my lord. Getting excited. Yes, my lord, here. This here, my lord, is flag marked here. Lord, you will kindly see. The second flag, my lord. It is deduction. First flag is the appeal, my lord, and the second flag is the result sheet. Note 25.
$810.
If your lordship permits me, my lord, only another alternative submission.
Yes, yes.
Lord, there is another source of power under the Act. My lord, vested with the register. That is, my lord, 111. Now, if, my lord, the register, my lord, is authorized, my lord, to pass an order reviewing, my lord, the order passed by his subordinate authority. If a order is passed by the government officer of the department, my lord, then he has the power, my lord, to interfere with the same order, my lord. And that power vests, my lord, with 111. Now, even if your lordship finds that this may not be an order under Rule 27, then it can be constituted, my lord, to be an order under 111. And the approval which was accorded by the assistant registrar, that has been, my lord, disapproved. If from another perspective, if your lordship sees, my lord, this order from that perspective, so therefore it can be constituted that the approval which was accorded by the assistant registrar, this has been disapproved in exercise of power under 111, my lord.
But this is entirely on a different context.
Correct, my lord, but
He
what I'm
is,
trying
he
to...
is sitting as an appellate authority
Yes,
over any orders passed by any other government servants subordinate to him.
yes, yes.
Now, here is an independent cause of action espoused before him regarding questioning the validity of an election.
Yes.
He has conducted hearings, which he is authorized to do. Now, this 111 is a different jurisdiction.
Now, what I'm trying to say, my lord, I don't have that notification. The power under 45 to, my lord, approve the resolution of the AGM election is conferred on the Assistant Registrar of Cooperative Societies. Essentially, my lord, they exercise that power. Either they approve or disapprove. So in this case, it was approved by the Assistant Registrar of Cooperative Societies, the election AGM.
Where is the approval?
No, in fact, he has also held that, but that is not on record. That is not on record, my lord, because he had, my lord, held that the application, my lord, of the private respondents, my lord, that is liable to be rejected.
There is no final decision
Yes.
of approval. Is there? We have not found any papers.
My lord, no, your lordship will see the order. Order is of, my lord, 24/1.
Yes.
And the election, my lord, having been held on 23/9, that has to be approved within 15 days under 45. If not approved, there is a dim approval under the Act. So it has to be understood, my lord, that it has been
No,
approved.
but by the time the appeal was filed on 6/10,
Correct, my lord, but there was no decision on that appeal. If your lordship comes to 45, my lord, what I'm all on is that there is a source of power under the Act. If your lordship holds that the exercise of power under 227 is bad, even then, my lord, a source of power remains, my lord, available with the register. And here, my lord, I may bring in, my lord, Sangeeta Theatre. Your lordship is aware, if, my lord, the wrong provision is quoted, that itself will not vitiate the order.
there is no dispute on a wrong provision, misquoting. There is no, but whether the provision of an appeal under 111 can be read into in these facts and circumstances. There are, see, the appeal is provided by 111. The another adjudicating authority has been also prescribed under the rules,
My lord.
which you have already led us, 27. 27. And who is the authority to adjudicate? It is the election authority. Election authority has been defined at 2F.
Correct, correct.
2F.
It's the same authority, it is register, my lord.
2F.
Yes.
Now, that appellate jurisdiction is an entirely different channel. Even there is no problem in your accepting a submission that this perhaps could have been construed as a appellate provision under 111. But is it an appeal under that provision? Can he exercise jurisdiction? It is not a question of approving or disapproving.
No, there is a question, my lord.
No, it is straight away an appeal questioning the elections
Yes,
by the
correct.
candidates.
No, correct, my lord. What I'm trying to say, your lordship, my lord, I'm subject to correction. My lord, the power under 111 remains in terms of section 45. it still remains.
No, that we have noted.
Yes, because under 45, my lord, approval is necessary for giving validity, my lord, to the election. Unless there is an approval under 45, the election result, my lord, does not stand, my lord, validated.
Is there an approval here?
The deemed approval is there.
No, no.
My lord, 15, your lordship will kindly come to
No,
45.
No, is there any subsequent observation of deemed approval?
No, your lordship, if your lordship kindly comes to
No,
45.
no, we have seen 45.
Yes. So therefore it
If
reads, my
seen
lord,
45, see, if you bring in the provision of due approval,
Yes.
it will be brought by the person who are being benefited. You cannot bring in a provision to advance your own case. Perhaps they could have brought it that way 45
no,
helps
my lord,
us.
this is statutory prescription, my lord. It's not
We
question of
know,
bringing
we
about-
know,
Yes.
we know.
My lord, it reads as follows: the registrar shall give his approval on the resolution within 15 days of the receipt of the proceeding. If no approval is received within the aforesaid period, the proceeding shall be deemed to have been approved. So this is the, my lord, mandate of law. And this power, my lord, is
You are
delegated.
reading which one again? please?
45 last, my lord, 3-4 lines, my lord.
Hmm.
Minutes of proceedings of the meeting, which
Yes.
includes meeting of, my lord, AGM election,
Now,
where
who will
the-
give the approval?
my lord,
Who has to give the approval?
as per the delegation of power, it's a assistant registrar of
No,
cooperative.
here as per the law, as per the provisions of this, 45?
45, it's the ARCS, my lord. The register, my lord, is mentioned here, but this power is by notification under section 3. If your lordship comes to section 3 of the act, my lord. 3
Yes.
subsection 2. This power has been delegated, my lord, by notification to the assistant registrar of cooperative societies. The state government, subsection 2, my lord,
Yes.
may also appoint any other person
Yes.
to assist the registrar and may by general or special order in writing delegate to such person or persons all or any of the parts of the responsibilities of the registrar under this act. My lord, perhaps I have this notification, I can place it, my lord.
Please do.
Blue folder here. এখন দিব।
What is the date?
My lord, it is 23rd May 2012, my lord. I have marked this, my lord. Highlighted this one.
Yes, please. Yes. Yes.
So subsequently, my lord, that was disapproved by the registrar.
Which was, what was disapproved?
The proceedings of the AGM election, my lord.
The impugned order.
Yes, yes.
Yes, anything else? Yes.
This is my.
Yes, yes, Mr. Make a short rejoinder.
My lord, the Assistant Registrar of Cooperative Societies have the power. By virtue of the power, he has utilized his power, my lord, on 6th October 2000, Annexure 6, page 41.
Minister 6.
Page 41, regarding recounting of votes, which was rejected. Unless he has the power, he cannot utilize. And he is one of the election authority.
No, he is not the election authority.
My lord,
Election authority.
Without election authority, how this order is passing?
No, Eastern Registrar is not the
Assistant Registrar.
election authority under 2F has to be defined.
Then, my lord, another order passed, my lord.
No, what
Kindly
did you
help me
want to submit so far as 41 is concerned?
Yes.
What is your submissions regards page 41?
My lord, regarding my lord, section 40.
No, you have just
Page 41.
led us to page 41. What is your submission?
My lord, page 41, my lord, regarding this recounting of votes.
Yes.
Recounting votes, my lord, unless necessary fees is given at the time of application of the recounting or thereafter, the recounting cannot be accepted, my lord. Then this was passed on 6th October, my lord, by the Assistant Registrar. And the same was further. My lord, this 6th October order was passed. Detailed report regarding the election and counting of votes of Udali, my lord, it is there. In the report, it is clear that your claim for recounting was not received within the specified time for receiving such claim, that is before the end of the counting process. Moreover, you have not deposited the required refundable fee before the returning officer. At the time of submitting your claim for recounting, your claim for recounting is not good in the eye of the Assam Cooperative Society Election Rule 2019. So that is why it was. Thereafter, this appeal was filed before the on same day, my lord. On the same day, appeal was filed. And my respondent filed their affidavit. Its preference was given only section 27, my lord. In the 27, your lordship, lordship kindly look, redressal of dispute. Any dispute relating to election of cooperative society may be submitted within 3 days from the date of declaration of the result. Declaration was given on 25. Before the election authority, B, the election authority shall make an inquiry upon the dispute on the basis of the relevant records and pass necessary orders. The election authority can pass the necessary order. Returning officer also in election authority. So, nothing was found in the impugned order dated 24/1/2024 regarding this, and no material was produced by the respondent before the Register of Cooperative Societies. Then how this election redressal dispute will come? Register of Cooperatives has the power under 111 of the Cooperative Act. Prior to that, the grievances already ventilated, but came to an end by the established cooperative societies. Came to an end through the order dated 6/10/2023. So there is nothing survived, my lord. And the impugned order is absolutely prejudice the right and interest of the petitioners. And it is not as per provision of law. Nothing was found against the petitioners. And the inquiry officer's reply is sufficient enough.
Why? How is it sufficient?
My lord, he has given it is human error.
What about the other aspect? Saroja Guest House.
My lord, this is the only recounting question of recounting, unless somebody is giving fees.
Now, what about the other aspect, that it was not taken straight to the police station or the,
My lord, on 20, my lord, on 9/2023, election was held. On 23, in the evening hours, this ballot box was taken to Lanka police station, my lord. Lanka police station. Lanka police station, in presence of all the contesting candidates, supporters, officers. And on 25 in the morning at 8 a.m., my lord, I have stated in my petition, 8 a.m., all officers along with the contesting candidate collected the ballot boxes from the Lanka police station. And the counting started. At the end, due to electricity problem, everybody admitted the fact there was an electric problem in Lanka area. So it is urban, rural area, my lord. So this electric problem, unable to complete the counting. So when unable to complete the counting at the wee hours, my lord, it was completed. After completed, my lord, it should be dated is 25/9/2023.
that is not the question.
That is only
That is not
criteria.
the question. Question is, why was it taken to a guest house instead of the police
My
station?
lord, as guest house, it was the returning officer who was taken to the guest house because he in the wee hours, my lord, police probably it is the best to
Now,
decide.
was the counting over before taking to the guest house?
My lord,
The counting was done thereafter.
my lord, the returning officer taken to the guest house after the declaration of the result.
After declaration.
After declaration, after issuing the certificate. After issuing the certificate, in presence of all the parties, all the other contested agent also. So what wrong has been done, my lord, that nothing was produced before this honorable court. That is the criteria. Only mistake is that it was 25 to 26.
Okay, we'll consider.
Oblige, my lord.
We'll retain the records, Mr. Chancellor. Third, the I.A. Talukdar Learned Counsel for the petitioner. Also heard Sri S.K. Talukdar, Learned Pending Counsel Cooperation Department, and Sri H. Das, Learned Counsel for the respondent numbers 6 and 7. Sri Talukdar has also, Sri S.K. Talukdar has also placed before this court the official records. Para. Hearing is concluded, judgment is reserved. Okay.
Obligation.
Okay.
And not I say? Your mother said that the money to believe. Yes, Mr. Watakul.
Lordship, what has transpired from the pleadings, Your Lordship, from both sides, Your Lordship. One fact is admitted, Your Lordship, that the land under occupation of the petitioner is under Your Lordship, VGR land, Your Lordship. There is no dispute about that. Your Lordship. What has happened here, Your Lordship? In these lands, they have also stated in their affidavit, Your Lordship. In 11 vigas of land, Your Lordship, the petitioner is, Your Lordship, occupying, and Your Lordship, a small tea garden is there, Your Lordship.
11 bigha.
11 vigas of land. Part of that, Your Lordship.
This is VGR.
His year, Your Lordship. When he purchased it, Your Lordship, he was not aware about that. In fact, it was occupied by some other persons, Your Lordship. From them, he purchased the position, your lordship, and then your lordship, he started constructing it, establishing that
Small tea garden.
small tea garden. And in fact, your lordship, in small part of it, your lordship, which is probably not part of VGR, your lordship, as per their affidavit. If your lordship comes to page 53, your lordship, affidavit in opposition filed by them, your lordship.
Out of 11 because some part is not VGR.
Not, no, your lordship. Your lordship may kindly come to page 53.
5-3.
53. They are affidavit, part of the affidavit, a communication from the to the circle officer, your lordship, by the additional executive commissioner.
53.
This 1 and 3, your lordship, is
No, not 53. It will be some other page. 53 is the
it was,
letter.
your lordship, the affidavit filed by the 2, 3, and 4, your lordship. Ankur Bharali, your lordship,
Just a minute.
Annexer 3.
It starts at page 85.
This running page has created some problem.
Yes, please. Which
Page, Annexer 3, your lordship.
can you say the internal page? Internal
The
page.
internal page is not there in my petition.
Wrong 53.
Wrong 53.
In annexure?
3, your lordship.
Which page, Mr. Nath? Yes, yes.
Lordship.
Page 99.
And
Is it 5-8?
5/8, your lordship.
Yes.
Now, your lordship, land measuring 5 gave us reserve Gopsa. This is under his possession. Land measuring 11 bighas. This is also reserved for Gopsa, your lordship. And number 2, your lordship, land measuring 2 bighas, 1 kathas, lesser dag number 88. This is not your lordship. Probably your lordship, it says Dolatok Panitol.
Dolatok Panitol.
Panitol, your lordship, not under Gopsa. Now, your lordship, so far as my case is concerned, your lordship, admittedly, your lordship, I don't have any right over the Gopsa land, your lordship. But your lordship will kindly see in my affidavit in reply, I have made a statement, your lordship, at page 9, immediately after that affidavit in opposition by the
Page 9.
para 9, your lordship. 62 number.
Of your reply affidavit.
Reply, your lordship. I have made a specific averments, your lordship, here,
Paragraph
paragraph 9.
9. Please.
That as regards the averments made in para 5 of the affidavit in opposition, the same are matters of record and the deponent does not admit anything which is contrary to or inconsistent with the record. It is stated by the deponent that even today there are people occupying different plots of land and under said dag. One Norua model agricultural farm consisting of 10 members are occupying and started sugarcane farming thereon. Similarly, some people, namely so and so, so and so, so and so, are occupying the said land, are doing fishery business. Surprisingly, the authority, without targeting the other occupiers, has specifically targeted the petitioner. This is your lordship, that your lordship, selectively targeting me, your lordship, that is my case, your lordship. And in fact, your lordship, it is from long, this is under occupation of various people. I purchased the possessory right, your lordship, then started this. And in fact, your lordship, I did it, your lordship, since there is a provision, your lordship, letter issued by the government also, your lordship, so far as those under occupation of small tea growers, your lordship, that will, they will settle the
with those tea growers on payment of premium.
Is there a policy?
Yes, Your Lordship, there is a policy, Your Lordship. That policy. Your Lordship may kindly see this, Your Lordship. This was, for long, this has been going on, Your Lordship. This is past 1994, Your Lordship. And in fact, in the budget itself, Your Lordship, declaration in 26 July 2016, this has been. So, Your Lordship, my prayer would be, Your Lordship, since I have already,
In this, what is there here?
Your Lordship, I have only one copy that I have handed over to Your Lordship.
No, this is for allotment to give incentive
Lordship.
to mainly three categories.
Lordship.
Indigenous youths of coming from families below poverty line,
Lord.
other indigenous educated unemployed youths,
Lordship.
cooperative societies. Now, where is the mention that even VGR land can be given?
No, Your Lordship, that is not there. That is not there, Your Lordship. That is my submission is that, Your Lordship, based on that, Your Lordship, expectation I have, Your Lordship, occupied. And in fact, I was not aware when this was taken that this is VGR land, Your Lordship. And there is a policy that, Your Lordship, that it will be incentive will be given. And in 2018 also, Your Lordship, there is an order by the government, Your Lordship, that which says, Your Lordship, Governor Assam is pleased to fix the settlement premium at rupees 1,000 per biga for settlement of land with the existing small tea gardens and also for the future small tea gardens, having registration with Tea Board of India, Directorate of Tea Assam, having extent of land up to 30 bighas, Your Lordship. Now, Your Lordship, that policy is in vogue, Your Lordship. There is no doubt about that. But whether, Your Lordship, for giving
Yes.
VGR land, Your Lordship, they will ultimately, Cabinet will have, Your Lordship, de-reserve it with the, Your Lordship, the recommendation of the Deputy Commissioner. My prayer will be, Your Lordship, since I am, Your Lordship, already in occupation, Your Lordship. First of all, Your Lordship, if Your Lordship, 15 days, 1 month's time is given, Your Lordship, my entire, Your Lordship, this tea bushes will be, Your Lordship, it will cause heavy loss to me, Your Lordship. And secondly, if Your Lordship permits, Your Lordship, me to submit an application before the government of Assam, Your Lordship, seeking, Your Lordship, de-reservation and settlement of this land. If
Reservation, is it possible of VGR land?
because Your Lordship will kindly see in some case even
Is there any leeway given in Jakpal?
no, Your Lordship, that is
That
not.
is very strict.
But only thing, Your Lordship, they have targeted me only. That is one aspect.
That we have not even asked Mr. Nath.
Lordship.
And regarding your time, is there an interim order protecting you?
Yes, yes, Lord.
What is the status now?
That is under my occupation and Your Lordship, I am.
No, the status of the tea,
That Your
tea
Lordship.
leaf.
That Your Lordship, tea leaves are there. This is growing, Your Lordship, from time to
How
time.
old is the garden?
Your Lordship, I have mentioned it, Your Lordship, in my.
More than 5 years.
No, Your Lordship, it started in the year 2007-8, Your Lordship.
So yielding period is 5 to 6 years of tea.
Lords.
Yes, Mr. Nath.
Well, in paragraph 3 of our affidavit, we have said, so admittedly, that particular land.
Mr. Borthakpur has been candidly said about his weakness in this case. After that, you can make a suggestion what can be done. Your submissions, obviously, we have understood. It's VGR land. There is no scope for conversion.
No.
His submission is mainly based on the long period of time, which perhaps will not give him any indefeasible right. But under that, those circumstances, what is your submission?
The VGR land, if the VGR land is under occupation from 2007-8 and the petition was filed in 2016, we issued the notice. The stay has been granted till 2025. He has enjoyed a lot by virtue of the interim order. So the VGR land has to be cleared, and we have taken a decision in 2016. So no right is there, and the Honorable Supreme Court's decision as well as the stand of the department is the authority is very clear. So he has to leave the VGR land, that is 11 biga and 5 biga. And as regard the de-requisition process, my lord, that is not permissible, and that cannot be considered at all, my lord. And as regard the other persons, my lord.
Yes, other
occup-
persons.
Other persons occupy, that negative equality he cannot claim. My lord, if there is any, my lord, the authority definitely.
No,
they will take
that is
decision.
absolutely correct. No negative equality under 14.
Lordship.
Even yesterday we have had.
My lord.
But Vizier, there is a sacrosanct duty of you to protect.
Absolutely, and this stand taken by.
I am not saying that you have given benefit to some in a illegal manner, so is entitled to the same benefit. No.
No, absolutely not.
But what is your action towards?
My lord, in the affidavit in paragraph 9 and 10, what they
Because
have said.
Vizier cannot be one plot in isolation.
True.
If the entire area is Vizier, is entire area have to be taken.
Yes, that has to be clear. That has to be clear, and that is the stand taken, my lord, and that action will take. And
Where have you stated?
my lord, in our affidavit, my lord.
Please show us.
Paragraph 6, my lord.
Page.
Page petition will be different. It starts at 85. Then, my lord, it will be 90 or 91. Para 6.
Your affidavit.
Of our affidavit. The deputy commissioner has filed the affidavit.
234.
234.
Ankur Bharali.
Yes.
Paragraph.
Para 6. At internal page 5.
Yes.
But we have said that it is respectfully submitted that in the instant case steps were taken to clear the encroachment of Vizier land, which is under occupation of the petitioner, and doing so, the provisions of Assam Land and Revenue Regulation 1886 as well as the policy of the government was taken into consideration. It is respectfully stated that the law laid down by the Honorable Supreme Court in respect of VGR and PGR provides that village common lands should be kept encroachment free and not be settled with anyone except for community purposes in exceptional cases, and in no case the area of VGRs and PGRs be reduced to less than 5% of the total village land. So we have reiterated the policy that it should not be encroached. Nobody will be allowed to encroach, and it will be clear.
No, you have only talked about the petitioner. What about the averments made that other persons are also occupying?
Malad,
Have you said that we are taking steps?
That has come after filing of our affidavit in the form of a reply.
Not in the writ petition.
Not in the writ petition. Not in the writ petition. So by taking that plea, he cannot be given any benefit, Malad. So the concept of negative equality comes here, Malad, that he cannot claim. It is a settled principle of law, Malad. And secondly, the subsequent para can you see, Malad? Subsequent para 7. As per clause 7 of the land policy of 2019, the deputy commissioners were entrusted to take necessary endeavor to preserve the existing VGRs and PGRs for use by the members of the public for the purpose for which those were constituted an encroachment of VGRs and PGRs, if any, will be removed. We have said, Malad. Further, it is mentioned that henceforth the land under VGR and PGR will not be further decreased by way of de-reservation and allotment, etc., except for public purposes under special circumstances as defined by judicial pronouncement. So this is our clear-cut stand. Therefore, when the petitioner is admittedly occupying the VGR land, that he cannot be permitted to occupy. And in
what is the citation of Jakpal? 2011.
2011, 11 SCC, page 396. Para 23.
11 SCC?
11 SCC 396. 396, para 23.
Okay. Anything else?
And my lord, in one of the paragraph, the petitioner has also taken in para 10 of the reply. They have taken a plea that 18-2 notice has not been given. Well, it is the law is well settled that these lands in respect of VGR land, that notice is not required.
Not required.
18-2 is not required.
Only thing, your lordship, in para 16 of my writ petition, your lordship.
Yes.
I have made a statement not the names are there, that the petitioner beg to state that all over the state the petitioner is the only small trigger who has been targeted by the authorities for eviction, although a large number of small all over the state are using the government land for purpose of the read stated that some other people in and around the petitioner's village has been growing tea bushes by occupying government, but the respondent authority has not asked them to vacate their respective lands, Your Lordship. That was, Your Lordship.
That is the reply you have taken.
No, Your Lordship,
but-
that is, Your Lordship, in the writ petition itself, Your Lordship. And then, Your Lordship, I have become more specific in
Which
reply.
paragraph did you make this?
Para 16 of my writ petition, page 11.
They said government land, Malad, VGR, not VGR land.
How do you support your plea that 18.2 is not required in VGR?
18 Malad, the law laid down by this division bench of the Honorable Court in Salakuddin case, para 63, it clears, Malad. That the
Yes, sir, what is the citation of Salakuddin?
Salakuddin, Malad, I'm just giving, Malad. 2024 4 GLT 857.
2024,
4 GLT
4
Eight-
GL,
857.
paragraph?
Para 63, Malad.
For reserved land.
The Honorable Court said that in respect of other land, that is land previously reserved for roads or roadside land, or for grazing of village cattle, or for other public purposes, or the occupants had entered into possession of the land for which he has been executed by general or special orders of such land, are outside the purview of settlement. So if the land is outside the purview of settlement, then 18 to question of 18 to notice will be.
It cannot be equated with government khas land.
Government.
VGR has they got a
Lot.
different status.
Lodged.
In fact, that was the emphasis in Jakpal.
That is the emphasis in the Jakpal, and ultimately that has been followed and held by this division bench of the Honorable Court. And so, Malad, as regard the other persons, Malad, the negative equality, Lordship, I would like to refer to 2025, Malad. There is a decision that 2025 SCC online SC 117.
Name?
Name is Josnamoyi Mishra versus State of Odisha and others. Josnamoyi Mishra versus State of Odisha and others.
Paragraph?
Paragraph 31 and 32.
Authored by whom?
Malad, the
Recent one.
recent one, Malad, on 20th of January 2025, authored by Honorable Justice B.K. Maheshwari and Rajesh Bindal. The Honorable Court has held that the litigant coming to the court cannot claim negative discrimination, seeking direction from the court to the department to act in violation of law or statutory rules. And the other earlier decisions have been referred here, Malad. Therefore, Malad, considering the entirety of the matter, Malad, the petitioner's claim in the writ petition that at page number 14 of the writ petition, Malad,
1-4.
1-4. He has prayed for a direction of like nature should not be issued, directing the respondent authority to set aside and pass the impugn notice dated 19/7/2016, issued by the Circle Officer Sonitpur, with reference to letter dated 3/8/2016, by the Deputy Commissioner Sonitpur to evict the petitioner from the land in his occupation and or all other consequential orders. So he has prayed for setting aside of that notice, Malad, by which he was directed to vacate the land. That notice, Lordship will find at page vernacular is at 30, translated copy at 29, Malad.
Yes.
So there is no ground for interfering with this notice, Malad, and this notice has been rightly issued by the authority, and therefore the petition is liable to be dismissed.
But are you saying that the area which is under the possession of the petitioner, it consists of both
Yes,
VGR and some other land?
yes, yes. In paragraph 3 of
You go ahead with the VGR land, but other lands you cannot. Is there a demarcation
in fact, yes, my lord, in paragraph 3 we have indicated.
of your affidavit?
In para 3 of our affidavit, we have indicated, my lord. If lordship kindly comes to the affidavit, my lord, para 3, as reported by the circle officer, Nodwar Revenue Circle, petitioner is running a tea estate in the name and style of MS Norwa Tea Estate. The said tea estate stands over Khiras periodic patta land measuring 30 bigha, 3 katha, 8 lesa, covered by DAG number 840 and 16 others of village so-and-so, Moja so-and-so of Nodwar Revenue Circle, and Khiras periodic patta measuring 13 bigha, 1 katha, 3 lesa. So 30 bigha and 13, total 43 bigha, he has periodic patta. And the mutation of the aforesaid land are in process in the name of the petitioner. It is we are not disturbing him. Second paragraph, in addition to the aforesaid land measuring 11 bigha covered by DAG number 910 VGR land measuring 5 bigha DAG number 508 and 2 bigha 1 katha 1 lesa DAG number so and so situated under so and so is under possession of the petitioner. We are concerned with this land. His patta land we are not disturbing. He'll keep on he'll going on with that. We are concerned only with the other part. Our notice is as regard this second portion of the land.
Okay.
Lordship, so far as your lordship, I know your lordship where I stand, your lordship. Therefore, your lordship, I have not argued anything much, your lordship. But only thing, your lordship, so far as this negative equality is concerned, your lordship will kindly see I have made some allegations in my writ petition, your lordship, regarding the person behind your lordship, at whose behest this has been done, your lordship, vendetta, your lordship, and keeping with that statement, your lordship, and the fact that your lordship, they have not touched other persons, your lordship, it shows, your lordship, it can also shows malice also, your lordship. That's only submission.
Malice in law, you can argue.
Lordship.
Malice in facts, difficult for you to either argue or to establish in a
Lord.
writ proceeding.
But your lordship, we can sometime. your
Malice
lordship,
in
we
fact
can-
to be established, you will have to have very, very what do you call, convincing kind of an evidence, which
Lord.
is difficult. Okay, well, we'll dictate at 2 o'clock.
Only thing, your lordship, I have to pray for some time at least, your lordship, so that your lordship, I can.
Lordship may record my objection because he has already enjoyed for nine years, more than 9 years he enjoyed. This should have been actually, he should have been evicted by this time. Lordship may record my objection, I leave it to your lordship.
ঠিক হ'ব নেকি এটা নহ'ব সেইটো মই 2টা বজাতে দিম মানে ভিতৰত পঠাই দিম চাই লওঁ আৰু কেইটা থাকিলে 16টা আছে হিয়াৰিং হিয়াৰিং পুৰণি আছে Okay, that will come at 2. The benefit of the policy which was advanced by the state to give incentives. Para? The rival submissions, Para? From the pleadings exchanged and the arguments advanced, there is no manner of doubt that the land in question is VGR land. Full stop. The petitioner has stated that it was the possessory rights of such land which was purchased by him in the year 2007, 2008, and at that time he was not aware of the status of the land. Full stop. Be that as it may, the status of the land being vizier is not disputed at all. The law laid down by the Honorable Supreme Court with regard to vizier land is clear. Full stop. In the case of Jagpal Supra, the Honorable Supreme Court has made the following observations. Paragraph 23. This court also finds force in the contention of the learned State Council that there would be no requirement of a notice under Regulation 18(2) of the Assam Land and Revenue Regulations in terms of the clarification given by the Honorable Division Bench in the case of Salakuddin. Full stop. In fact, Sri Bhattakur, the learned counsel for the petitioner, has fairly conceded to this aspect of requirement of such notice. Full stop. Para. As regards the plea of discrimination, comma, it clearly appears that such plea is based on a negative equality, as possessing vizier land is impermissible in law. Full stop. It may be stated that the Honorable Supreme Court in the aforesaid case of Jagpal has laid down strict conditions and so as to ensure that all vizier and community land are made free from any encroachment. Full stop. This court is also of the view that in this court is also of the opinion that in view of such clear directions, comma, even the policy to give incentives to small tea growers would not come to the aid of the petitioner. Full stop. Be that as it may, the communication dated 23/9/1994, which has been placed on record, 1994, issued by the Revenue Department, which has been placed on record, has been perused, and the said communication is only with regard to allotment of land to mainly three categories, namely 1, 2, 3. 1, 2, 3. The said communication, however, has to be read in conjunction with the law laid down by the Honorable Supreme Court that such land cannot be vizier land. Full stop. In the conspectus of the aforesaid discussion, this court is of the opinion that there is no scope for granting any relief to the petitioner. Full stop. The writ petition is accordingly dismissed and the interim order is vacated. Full stop. At this stage, Sri Bhattakur, the learned counsel, submits that some time may be granted to vacate the land as the same is under tea cultivations. The aforesaid prayer is, however, strenuously objected to by the learned State Council, who has submitted that in terms of the interim order, the petitioner has already availed the benefits for the last 9 years. Full stop. Para. Be that as it may, by balancing the equities, it is directed that a period of a month from today be granted to the petitioner to vacate the premises. Full stop. If if it is however made clear that after expiry of a month from today, the state authorities would have all the liberty to go ahead with the eviction process.
Lordship, can it be 2 months, your lordship? Because key buses will have to be, your lordship.
1 month is enough, I think.
2 months, your lordship. Yeah.
45 days.
Lordship.
45 days. Though it is also observed that such eviction process are not necessarily to be confined to the petitioner, but for clearing all VGR lands.
Obliged. Obliged.
Yes.
Lordship, in this matter, the conducting counsel, Mr. A.R. Bhuya has suddenly, Lordship, his health has deteriorated. So, Mr. A.R. Bhuya, the conducting counsel, his health has suddenly deteriorated.
Okay.
Lordship. So, Lordship, can.
What is this matter, Mr.?
Matter
Pertaining to my lord eviction from the Sonapur tribal belt area.
Yes, Lordship.
Pleadings are complete, my lordship may kindly peruse the last.
No, we have seen that. We'll have some other day, but not
Any day next week.
hmm?
Any day next week.
Next Monday
Next Monday,
or Tuesday,
Tuesday, my lord.
whichever suits you.
Next Tuesday or Thursday, Lordship.
Next Tuesday, Mr. Borthakur, Mr. Borpujari,
My lord. But can it be on 21st, my lord, Thursday?
whatever you say.
My lord? Because
It's up
they
to
are
you.
repeatedly taken, I cannot even object, my lord. On
No,
any
some
ground.
medical grounds. So we are suggesting Monday is okay for us.
Next Monday.
Yes.
Yes, my lord, let it be on
Next
next
Monday.
Monday. Yes,
Okay.
I am ready.
A prayer for adjournment has been made on behalf of the A.R. Bhuya, Learned Counsel for the petitioner on health grounds. Full stop. Para. Sri R. Borpujari, Learned Standing Counsel, Revenue Department, has submitted that since the adjournment has been sought on health grounds, he would not have serious objection. Full stop. At the same time, he has emphasized the urgency involved and has prayed for an early date. Well, considering the above, while this case is adjourned for today, it is directed to be listed on Monday.
Lordship, interim granted earlier.
Interim order passed earlier to continue till the next date of listing.
Highly obliged, Lordship.
So obliged.
Both matters?
Both
Yes,
matters,
Lord.
my
Okay.
lord. Item 4 and 5, my lord. I am obliged, my lord.
May it please your lordship. As per order dated 21/4/25, we have filed a reply, lordship, to the affidavit filed by the district council.
Or the rejoinder has been filed?
Yes, lordship.
Okay, if you want to go ahead, we can.
Yeah.
Who is for is for KSCS or NCHAC?
And this is the DH, Dimahasa, lordship.
NCHAC. Are you there?
Some instructions were also asked from the Dimahasa of.
Madam Goswami, for whom?
For respondent number 7. The company. In item 6 and the petitioner in item 7.
You are also challenging your cancellation.
No, lordship, it is our land. It has been allotted to us.
No, your challenge is regarding your petition. What is your challenge?
Lordship, we are not challenging. My petition, we had come first. The first, item number 7 is the first petition actually.
No. What is your challenge then?
Challenge, no, we wanted protection. We got possession on 30th of September. The very next day when we started going to ground, the local miscreants who came and obstructed our work, we wrote to the SP, OC, nothing happened. We were compelled to come to your lordship's court and we got interim protection which continues. Item 7.
What company?
Mahabal Cement.
Cement.
Cement company.
You have been granted an area of land.
Yes, allotted 3,000 bighas.
3,000 bighas?
Yes, your lordship.
The entire not NC district?
Lordship, I don't know the extent of the entire.
What is going on?
No, no, Lordship.
3,000 bighas allotted to a private company.
Yes, Your Lordship, for establishing, there is a mine.
We know, madam. We know about something about NCH.
It's
NCH.
barren land and it's
We know how barren is NCHs. 3,000 bighas. What kind of decision is this?
Lordship, I'll show you the.
They will have a mine over there.
Yes.
For limestone.
Mr. Sharma, 3,000 bighas? Is this some kind of joke or what?
No, no, Lordship, we need it. It's because of.
Your need is not the issue, madam. Public interest is the issue.
Lordship, there was a challenge.
How do you allot 3,000 bighas for a company?
Lordship.
Do you understand the magnitude of 3,000 bighas?
Lordship.
It will be the entire district, half of the district.
It's from 26 kilometer to 27 kilometer of Garampani National Highway.
26 to 29.
26 to 29. And Lordship, we are not interested in taking over somebody's land. It's a marble company by tender, cement company by tender. We've got the mining lease. By way of
Let us
tender,
see the
we've been
policy. We
granted.
are very interested to know the policy. How did it occur that 3,000 bighas would be given to a company?
Lordship, that is not the issue here.
No, that is the issue, madam. We are exercising rich jurisdiction.
Yes, yes.
We are entitled
Lordship, I don't
to
doubt,
know
I
what
don't
is the
doubt.
policy
Yes.
involved. Yes, Mr. Sharma.
But that, I think.
How did it originate? Let us see. We have had 100 bighas, 200 bighas, 3,000 bighas.
Lordship, the initial allotment was 2,000 and then we got an additional 1,000.
You must be very, very influential, madam.
Lordship, we are one of the largest cement company.
We
Yes,
have not,
Your Lordship.
you have not used the term is largest. We have said you must be very,
Lordship,
very influential.
My instructions are
Getting
limited to
3,000
my.
bighas in NCLs. Yes, let us see the decision, Mr. Sharma. We will like to see the decision. What is your case?
Lordship, the allotment.
Your Qatar.
Lordship, yes, Lordship. We are residents of 29 kilo, Lordship. Our village is Nobody Lonku Kro. We are.
Who are you?
Lordship, we are the residents of Nobody Lonku Kro, Lordship.
You are the villagers.
Yes, Lordship.
What is your case?
Lordship, our case is that we are traditional landowners under the ALRR section 47, Lordship. We pay house tax, Lordship. That is our usufructory right.
These are council lands.
Yes, it says khas land, but then we have been given possession of the land.
That is the normal practice, council land. Okay.
Yes, Lordship. In 6 scheduled areas,
Yes,
that is the practice, Lordship. So when they entered our land, Lordship, we did not know that they have been already allotted the our land, Lordship. So, and even the extent of the land, whether it is covering our village, only the farm areas, we do not know, Lordship. That is
So what is your case?
our case is that we should not be evicted, Lordship. From that area, our farmland should not be harmed. That was our.
What is the demarcation, madam, of your land? 3,000?
It's ongoing. It's not completed. And in fact,
you must be having some kind of, you don't get, you have got a lease or what?
yes, Lordship, the
Lease for how many years?
lease
99
is for
years? Or 9,000 years?
30 years.
Only 30 years?
Lordship, may see page 46, the allotment letter of
337?
337, yes, Your Lordship.
Page?
46.
46.
Lease deed through Asila.
46, yes.
Page 46 is the first allotment. Your Lordship has 14th October 2024.
How are you selected?
Lordship, the tender, there was a tender for the mining lease.
Let us see which tender.
That is not part of this.
Mr. Sharma, we'd like to see the process.
Lordship may kindly peruse Annex 5.
We'd like to see the process. How who took the decision to lease 3,000 bighas of land for a cement company?
Additional Secretary Revenue
It
demands.
will be the entire Garampani area, entire Umrangsu. Get the records. We'll have some other day.
Yes, sir.
Ah. What is this IA, Mr. Qatar?
Yes, Lordship.
IA for?
Against their petition, Lordship,
For stay vacating.
stay vacating.
What kind of stay is there?
Because since they had said that we are miscreants, Lordship, and then they had not told the court that actually we are the residents
What
of
is
that
the
area.
interim order in their
Interim
favor?
order was, Lordship,
What is the interim order?
police protection so that they can carry on their work,
Dated
Lordship.
29/1/25. Lordship, may I take 2 minutes? 29/1/25 in our writ petition, which is continuing.
Okay, well, we are not passing any other orders. Okay. Both these writ petitions are connected, full stop. While WPC 337 of 2025 has been filed by the company which has been allotted land for construction of a cement factory. The petitioners in WPC 467 of 2025 have alleged that they are being evicted from their lands in the Limahasau district, which they are possessing lawfully. Full stop. A cursory glance into the facts of the case would reveal that the land which has been sought to be allotted is about 3,000 bighas, which itself appears to be extraordinary. Full stop. Ms. Goswami, the learned counsel has, however, submitted that such allotment has been made pursuant to a tender process.
Mining lease has been pursuant to tender process. So this is a part of it.
Mining lease. But how about what about the allotment?
Lordship, the
That the
allotment
mining lease was done
was
under a
it's
tender
a captive
process.
thing,
Full stop.
yes. It's part
This
of
court directs the Sri Sharma, learned standing counsel, NCHEC, to obtain the records containing the policy to allot such a huge chunk of land measuring 3,000 bighas to a factory. Full stop. The aforesaid direction has been given by taking into account that the district is a 6th schedule area where the priority has to be given to the tribal people residing there.
Lordship, may I just make a submission if it can be noted? Page 29, his allegation is he's evicted. There is no averment to that in any of the affidavits.
We have not said anything in his favor.
No, Lordship,
List on when? When can you get Mr. Sharma? Not 4 weeks. You just need to have the policy and place it before the court.
Policy 9, eh?
We'll give a date. Madam, you may not have the expertise personally, but do you think the 3,000 bighas, are you aware how big will be 3,000 bighas?
Lordship, apparently it's
Then
for
it's in
the
a switch-
development of the area.
Development?
Yes, Your Lordship, because
In a
it's
cement
barren
factory, you
land.
will destroy everything.
No, Lordship, there's nothing.
You'll destroy everything.
Bring it.
We know what was going on in Umrangso cement factory. People could not live there
No, Lordship, for that. you
because
have
of
to get
pollution.
EAI, environment
3,000
clearance and
because
everything.
where will the people go?
No, Lordship, may I just take 1 minute? Initially, the land
Okay,
was
date,
given.
Mr. Sharma.
There is nobody in this land. That is my instructions. And therefore, even their writ petition.
Have you been there?
Lordship, I've seen pictures, yes.
Picture, have you
And
been
videos,
there?
and videos. No,
Please,
Lordship,
please
I
go
don't
there.
to my clients.
Please go there. We have been there personally.
That you would know. But I have seen pictures too.
You go there.
When I got instructions that nobody is displayed. And that is my instruction. No one so far, by way of demarcation, has been displaced.
It's not a question of displacement. It's a question of policy decision to have a cement factory of such magnitude covering 3,000 bighas.
Lordship, they challenged it
Okay.
by way of
Yeah,
PIL.
yes.
They withdrew the PIL and the order is if anybody is affected, please come. So they have to show that they're affected. They are nowhere in the picture. The prayer
PIL
is
can be taken
clarified.
up, PIL can be taken up in a
Yes, sir.
suo moto also. That's not a
Of course, Your
problem.
Lordship, of course.
Yes, they
I
did.
don't doubt that.
Not 4th of September, on the 1st of September. On 1st of September, Monday. Let's see.
Obliged, Your Lordship.
Ballot, item 8 and 9 both deal with similar issue. Ballot. Here, the petitioner made an application for mutation of ancestral property.
Maiden?
Application for mutation of ancestral property before the circle officer Nilam Bazar. It is in the Sribhumi district. But the petitioner has been informed by the revenue official that in the Sribhumi district, under the revenue circle, the land record have not yet been computerized. Due to non-computerization of the record, they could not process the application. Here in this case, the district commission has filed an affidavit. The district commission has also admitted that several letters were written to the director of Land Survey Assam for digitization.
But now there is an instruction that,
Yes, Lord, I
that
have
the
read.
process of digitization is
for
on.
process of digitization,
It's on.
and in fact, he has
It will be
admitted that
completed within a month, Lordship, as I have been informed, Lordship.
So I think your grievances would be met, I think redressed.
in fact, district commissioner himself admitted that the people of that revenue area, revenue circle area, they have been suffering due to non-computation of the record, and ultimately
No, they have already stated that
my lord.
as on date, the matter has been taken up and necessary action has been initiated by the directorate for digitizing the land records in the interest of public. 1 month they'll complete it.
So, my lord, petition be disposed of with the direction that within 1 month, my lord, they can.
Okay, you have the
That-
instructions? Okay.
Yes.
Both are similar.
Both are
Similar.
similar. In
This instruction is for that area, Lordship,
that area.
that
In item number 8, my lord, it is
Moja Pharma Pasha.
for mutation of ancestral property in item 8. In item number 9, there is a sale deed, registered sale deed, my lord. On the by virtue of the registered sale deed, mutation should be done, my lord. Mutation is required to be done, my lord. In both the petition, my lord, district commission has filed everything.
Three zero four three, 3045. You are the counsel in both the matters, Mr. Islam?
My lord, I am the counsel, my lord.
Okay. The subject matter involved in both these petitions being similar, those are taken up for a common hearing and are disposed of by those are taken up for an analogous hearing and are disposed of by this common order. Full stop. The disposal is also on account of the fact that affidavit by the concerned district commissioner has been filed, and the Learned Standing Council has also placed on record the latest instructions. Para? The grievance of the petitioners in the two cases is with regard to the inaction for finalizing the application for mutation of their respective plots of land. Full stop. So far as the petitioner, Sanjeev Roy, in WPC 3043 of 2025 is concerned, he claims to be a successor and possessor of different plots of land for which he had made an application on 16/5/2025 for mutation. The said plots of land, the description of the said plots of land are as follows. Dag number, person number, dag number, let's put to. Where? So far as the petitioner Muhammad Sarifuddin in WPC 3045/2025 is concerned, he has contended that he had purchased a plot of land measuring so and so, covered by Doug number so and so, airport area, wide a registered sale deed number 2681 dated 20/11/2020, and thereafter had made an application for mutation dated 17/5/2025 before the circle officer, Nilambazar Revenue Circle, which has not been acted upon.
Yes,
Para. Sri M.A. Islam, Learned Counsel for the petitioners has submitted that the application filed for mutation are liable to be acted upon and brought to a logical conclusion, which is a right conferred to the petitioners. Para. Ms. G. Hazarika. Who has filed the affidavit? District Commissioner.
Yes, Lord.
Sri H. Sharma, Learned Additional Senior Advocate Assam, has submitted that the concerned District Commissioner, Sri Bhumi, has filed affidavit in opposition in both these cases. Full stop. By drawing the attention of this court to the same, the Learned State Council has submitted that the delay in considering the application is because of the reason that the digitization was incomplete. Full stop. He has, however, contended that the said process of digitization has been initiated and would be completed shortly. Para. Endorsing the submissions of the Learned State Council, Ms. G. Hazarika, Learned Standing Council Revenue Department, has placed before this court an up-to-date instructions dated 11/8/2025 issued by the Office of the Director of Land Records, Assam, as per which it has been informed that necessary action has been initiated by the Directorate for digitizing the land records of the concerned area. Para. From the above discussion, it appears that there is no dispute involved in the issue which relates to finalizing the application for mutation. And the reason which appears is because of non-digitization of the land records. Full stop. Both the affidavits in opposition filed in these two cases, as well as the written instructions dated 11/8/2025, would, however, show that the steps have been taken for digitizing the land records. Full stop. Ms. Hazarika, the Land Standing Council, has submitted that such process would be over within a period of a month.
1 month.
We didn't know. Is expected to be over. Is expected to be over within a period of a month. Para. Considering the above facts and circumstances, this court is of the opinion that since the issue involved would be redressed upon digitization of the land records, which is expected to be completed within a month, there is no requirement to continue with the writ petition, and accordingly the same are closed. Full stop. It is, however, directed that the aforesaid process of digitization of the land records be completed expeditiously, and thereafter the application for mutation submitted by the petitioners be acted and brought to a logical conclusion without any further delay. The written instructions dated 11/8/2025 is made part of the records.
Lordship may direct them to complete the process within at least 2 months time, within 1 month, if they are digitization
We said
process.
expeditiously, and in any case, Mr. Kinnan, in any case, within an outer limit of 2 months
2 months.
APR lens.
from such date, yes.
My lord, in both the cases, my lord, petitioners, my lord, medical students of Jorhat Medical College.
Yes.
And they applied and got admitted in scheduled caste category, my lord. Their certificate, my lord, suspected. And my lord, FIR, my lord, lodged. FIR is page, my lord, 48. Page
FIR lost by whom?
My lord, Jorhat Jila Anusujita Jati Chhatra Hogdha. So, my lord, my submission that, my lord, in my lord, such cases, my lord, several judgments also there. If my lord certificate is suspected, they have to, my lord, lodge a complaint before the state level scrutiny committee.
Madhuri Patil.
Yes, Madhuri Patil.
Our High Court judgments are so dear. Sanjay
Yes.
Kojundar and all.
No, it-
FIR does not lie.
No, it will all follow the guidelines of Madhuri Patil.
Madhuri Patil, yes. And our, my lord, there is a standing, my lord, committee is there, scrutiny committee is there. If they, my lord, like to lodge complaint, my lord, they approach the, my lord, scrutiny committee.
Is the complainant made a party here?
Yes,
They have appeared.
no,
This matter is pending since 1819.
yes, my lord, 18.
What is the status? Is there any interim order?
Interim order.
Not to go ahead with the police case?
Well,
What was the interim order?
so interim order, my lord, stay, my, stay is there.
Interim order is there.
Yes, in both the cases, interim order. Further proceeding of
Jorhat PS case is hereby stayed. Have they appeared or not? Not appeared.
Not the pair, my lord.
Served or not? Okay, there is, it's complete. Well, I'll dispose this off. Mr. Das, we'll dispose this off.
Can be disposed. Well,
no
following the
point.
guidelines of Sanjeev Majumdar case is also there, man. It's stated very specifically.
And that
FIR
Abhishek case is also there,
Yes,
I
yes,
think.
Tripura case, my lord.
I have 3 judgments with me, my lord.
Abhishek Chandra, what was the case?
My lord,
Following
one
Madhuri
is
Patil?
Rajesh, my lord, Jaiswal. Another is my lord, Sanjeev Majumdar.
Sanjay Majumdar conviction.
No, Tripura case, Chandra.
Yes, yes, yes. In this case is there, my lord. Abhishek Chandra.
Abhishek Chandra is there.
Is also there.
This will do everything.
We can make the interim order absolute.
Yes.
Both the matters are similar.
My lord, in second case, only 1 person. Here, my lord, 6.
In the first one, 6 persons. Okay.
Yes.
Tell. Both the writ petitions being filed with identical causes of action are taken up for an analogous hearing and are disposed of by this common order. Full stop. In the first writ petition 6-1-2, 2018, there are 6 numbers of petitioners, whereas in the second writ petition, WPC 3528, 2019, there is 1 petitioner. Full stop. Para? as per the facts projected, all the petitioners were admitted in the Jorhat Medical College in the MBBS course. MBBS course under the scheduled caste category. Full stop. While they were pursuing their course, FIR was lodged by by an organization, namely All Assam Scheduled Caste Students Union, whereby it was stated that the claim of the petitioners to fall under SC category was false. Full stop. At that stage, and based on the said FIR, police case was lodged, and at that stage, the petitioners had approached this court. Full stop. Para. While these cases were considered at the motion stage, this court was apprised, and this court had taken into consideration the law laid down in this subject by the Honorable Supreme Court in the case of Kumari Madhuri Patil versus Additional Commissioner, Tribal Development, reported in 1994, 6 SCC 241. Full stop. As per the said decision, an allegation of the present nature is to be looked into by a scrutiny committee which has already been constituted pursuant to such guidelines. Full stop. This court was also apprised of a decision rendered by this court in the case of Abhishek Chandra versus State of Tripura, reported in 2011, 4 GLT 431. Full stop. Para. 3. As shown, learned counsel for the petitioners has submitted that resorting to filing of a police case is not permissible in view of such guidelines, and it is the jurisdiction of the scrutiny committee which has been constituted as per the direction in the case of Kumari Madhuri Patil, which will have jurisdiction to look into the matter. Full stop. 3. And thus, learned State Council has submitted that the matter, the competent authority to look into a dispute of the present nature would be the scrutiny committee. Full stop. He has, however, added that in case the present petitions are allowed, the complainant in this case may be permitted to approach the competent committee as the issue involves are serious, wherein genuine persons belonging to the SC category would be deprived. Are you appearing? Sri Sharma, learned Standing Council, Social Welfare, some of the Social Empowerment Department has endorsed the views expressed by the learned state council. Para. After hearing the learned council for the parties, this court has perused the office notes connected to the writ petitions, wherein from where it appears that the private respondent who were the complainants have been served and they have chosen not to appear. Para. The issue involved is with regard to the action of the private respondents to lodge police case on the suspicion that the petitioners who had taken admission into the MBBS course in the Jorhat Medical College on the basis of SC do not actually belong to the said category. Full stop. As rightly pointed out by the learned counsel for the parties, such issues are to be looked into by the duly constituted scrutiny committee as per the direction of the Honorable Supreme Court in the case of Kumari Madhuri Patil (Supra). Full stop. Taking recourse of a police case or lodging an FIR would not be the correct course of action. Full stop. This court has also noticed that while issuing notice, there is an interim order not to proceed further with the respective police cases. Full stop. Para. After consideration of the facts and circumstances, this court is of the considered opinion that the petitioners have made out a case for interference. Full stop. Accordingly, the police case registered are quashed, namely quashed. Full stop. The present order, however, shall not be a predicament for the private respondents to take up the issue before the duly constituted scrutiny committee, as indicated above. Both the writ petitions accordingly stands allowed. Interim order made absolute. Yes.
That's it.
Supply.
May it please your lordship, Malada, before I proceed, on last to last order, there was a direction that for further hearing, my friend took an objection that he doesn't want to do the case in front of this court because he is insisting on a part. I don't know. Please, you have yesterday said it's a part.
Yes,
Please.
Sit down.
Parthad, there is nothing mentioned as Parthad. Nowhere it is mentioned as Parthad. Now, my lord, your lordship, last occasion has directed that it is to be listed before the appropriate bench. The registry thought it fair and they have decided this is the appropriate bench. My lord, I am ready to do that.
Matter pertains to which
bench 5. And this is the
bench 5.
The bench 5, yes, my lord. This is the appropriate bench. Only there is nothing in the mention of a Parthad. For what purpose, I don't know. Well, only for the hearing.
No, we don't mind taking up a matter.
But I can place the matter. I'm ready to argue the matter.
What is the matter about?
My lord, this is a issue.
But Mr. Roy Chaudhary, without going into the aspect whether it's Parthad or further hearing, if you think that a court had given some time to a matter and both of you had extended arguments, advanced arguments, then to save time.
Well, that prior to that court, we have made argument before Justice A.D. Chaudhary for 5-6 times. then also we have done an argument for a quite a longer period. During that time, they have
No,
raised that.
5, 6 times is not the
Quite
issue.
a considerable
The
period of time.
issue is how many, what was the length, the duration of the argument?
Now that was the duration. Your lordship may look into
The duration can be 1 minute.
that. No, no, no.
Duration can be 1
During
hour.
that time also,
We're on the
duration,
duration. We are not on the date of the hearing.
duration also, there was quite a long duration. The
What is
order
the
will
issue?
reflects.
What
The
is the
order
issue?
will reflect.
What is the issue?
The issue before is about another thing. This is between some encroachers in a land. There is no locus because he is for
What is my locus?
Please.
Mr. Gulda, you sit down. You sit, you have.
He is for one Coverston committee,
Lordship.
where he is saying that I am a Coverston committee, whereas for another Coverston committee, the next person, Mr. Dhar, who has been led by Mr. K. N. Choudhury, he is also for one Coverston committee. So there is a dispute between two Coverston committee. My lord, my prayer, the only issue
You
is
are Kabarstan committees.
they are the two Coverston committees. I am the tenanted shops, whereas a civil suit is pending, and I am for 50, 60 years by the outskirt of the Coverston area.
You have a shop.
We have shop around 70, 80 shops.
You have been let out by the Kabarstan committee. And what is your grievance?
My lord, government has issued a notice under 18.2. My submission, 18.2 is not applicable. 18.2 cannot be applicable in a Kabarstan area. But I will place the law because the moment it is an admitted fact and by a judicial order, this Guwahati High Court has directed the government, prior to that they issue a 18.2 notice. As per 18.2 notice, the government said, you only dispose of their claims and please see whether it is a government land or not at all. If it is not a government land, 18.2 will not come. If it is, and it is we have raised that point before the commissioner authority, but the revenue authority. Revenue authority.
As per you, what is the nature of this land?
This is a trust and Islamic under the Waqf Act. My lord, if a regular particular immovable property or a movable property is used by the Islams for a considerable period of time, it goes under the Waqf Act. Under the Waqf Act, if there is some encroachers, notice will be under section 54 of the Waqf Act. And there should be an inquiry because there is a judicial order. Under capital 3C, there is a
of
Waqf Act. Under the capital 3C, the commissioner, before passing this input order, should have gone for an inquiry to see whether, because there was a judicial order. But I am placing the judicial order. Your lordship will find earlier when 18.2 notice was given. Now, my lord, government has only passed that input order.
Government was for the government.
Let them say about why not an my lord, Waqf property. I am placing before my lord, my friend starts. My lord, I take your lordship to that particular order by this court. My lord, at page 160, my lord, your lordship will find that judicial order was there. They have issued notice under 18.2. Then court said,
we have called you before the fire has started.
My lord,
call for the fire brigade.
My lord, I'm placing that paragraph 7. Before parting,
you douse the fire, then we'll start the hearing.
This court finds it relevant to observe that the power to be exercised by the revenue authorities under Rule 18 of the 18 settlement rules is only permissible if the land is a government land. The petitioner are at liberty to take the ground if the land under their occupation are not government
I
land.
understood your matter. You say that it is not fall under the ambit of 18 to.
They can issue notice if
it is a
under
Waqf property. Before you go for an eviction, you have to get an inquiry done. That has not been done.
And we have raised that point. That impugn order itself says. But I take your lordship.
Which is the order impugn?
Page 162.
162.
62. And in the Chitta, my lord, Chitta, what they have said, that it is reserved for Kabarstan. And it is an admitted fact that, my lord, it has been used for a considerable period of time by the Kabarstan committee. And, my lord, the present act and the amendment also says, my lord, the amendment, my lord, says of the Waqf Act, it says, provided the existing Waqf by user properties registered on before the commencement of the Amendment Act. Waqf by user. My lord, second paragraph your lordship will find when the Honorable Guwahati High Court in the order such
which page?
Page 162.
162.
Second paragraph, my lord. Because there was already in 160, there was an order from this court to look into the matter. And my lord, here we have raised this point. Fourth line, over applied schedule of land which has been
Fourth
reserved.
line of page 161.
262 para second.
Second paragraph. Further, which one?
My lord, the bona fide right involved in the applied schedule of land which has been reserved in favor of Adgaon Kabarstan. So my lord, we have raised this point and
Yes.
there was a permission
But
given to
the
us.
High Court,
In the whole impugn order that
answer.
nothing has been done. No inquiry, nothing. Only 18, again 18.
Now,
18.
what is this direction? What is the
Direction, my lord, to evict all of us under Rule 18, which is not permissible. And there is a stay order. Thus, the petition thus disposed of, the circle officer got a revenue here directed to initiate under ALLR under the existing rules.
Does a property, a government property automatically becomes a
My
Waqf
lord, because
property?
if you do not mean a government
is there-
property,
is-
had they would have said Sarkari land. They have said reserved for Kabarstan. And by user, Waqf by user means it's a Waqf property. If not today, we are here for 50, 60 years. Let them come and find an inquiry. Under the rule, it provides that.
No. What is the deeming clause that it becomes a Waqf property?
My lord,
Is there
here,
a deeming clause?
My lord-
Let us see the Waqf Act. Open a W.
if I go for the definition under 3R, three small r.
Yes.
Waqf means the permanent dedication by any person showing or demonstrating that he is practicing Islamic for at least 5 years of any movable or immovable property.
You are
having
reading 3.
R, small r.
That is Waqf.
Waqf. Definition, my lord, it gives. He is 5 years of any movable or immovable property.
Which
Three small r, my lord.
which act are you reading?
My lord, 1995, Unified, my lord, your lordship will find the Unified Waqf Management, Empowerment, Efficiency and Development Act 1995, earlier known as
Waqf Act.
Waqf Act. my lord.
Yes. 3R is Waqf means the permanent dedication. by any
Dedication, but then, my lord, it was amended in, my lord, 2025, and any person, and it was inserted.
5 to 9 এখন নতুন
Your lordship, your lordship, may-
24.
and then, my lord, your lordship may look into,
24.
my lord,
পিছত বোলে হেৰি আছে।
Proviso 2. Proviso 2,
We'll do one thing. We'll have it some other day.
my lord, your lordship may fix it on 21st. 21st, my lord, this.
Yes, what do you say, Mr. Bhojari?
Yes, my lord, I will go by the speaking order that has been.
Is it a Waqf property?
No.
First.
No.
It is in the chitta, it is there. Kabarstan.
Kabarstan.
No. Is it a Waqf property?
My lord, they have to go. The provision is there.
Then Waqf property.
Because, my lord, the chitta itself says, when the immovable property has been used for a considerable period of time, it automatically goes for a.
Chaudhary, that would be your submission.
My lord.
But based on your submission, there has to be an overt act
Absolutely.
by saying that this property has been, or
My lord, your
there
lordship-
has to be a deeming clause
My lord.
by which the conversion, it has been converted to a Waqf property.
My lord.
Unless there is any document.
If I have.
Perhaps,
if-
my lord, with all respect, my lord, my learned senior colleague has missed out the basic tenets of revenue jurisprudence. First of all, my lord, in a chitta, what is, my lord, mentioned? The chitta is my lord, right, where, my lord, the government properties are incorporated, government land. And, my lord, under Rule 18.2, 18.2 envisages various situations. One of such situation is, my lord, if a property is reserved for any public purpose, there has to be an owner. Who is the owner? Owner is the government, and it is reserved for, my lord.
No, here he is also not confused, my lord,
My lord,
because
it is reserved.
automatic,
Please.
before the government declares it as a Kabarstan, will find out from their documents, 70, 80 years behind the back, my lord, there was a Waqf, it was given to the Waqf. And Waqf has given that as a caretaker to the.
So, Rajchandra, you are before us, you'll have to show that, you can put the burden on them. Let's show
Because
the
there was a
document.
judicial order.
Let us see.
There was a judicial order at page 160, my lord.
160, let us see.
Para 7.
Para 7 we have seen.
My lord, they have said, my lord, only if the land is a government land and
Yes.
the petitioner liberty to take the ground. We have taken the ground before them and they have not done. And
No,
my lord,
by simply saying that it's Waqf property, that you are not discharging your burden.
my lord, here
If
under
you are trying
this-
to take any advantage that it's an Waqf property,
My lord,
the burden is upon you to establish that it's an Waqf property.
I will place it is Waqf by user, an admitted fact. Is Waqf by user. My lord, the amendment of Waqf properties, my lord, it has said, my lord, I'll place it that way, my lord. The proviso that was added here, my lord, provided that the existing Waqf by user properties registered on or before the commencement of Waqf Act of 25 as Waqf by user will remain as Waqf properties except that
This
the property.
list was instituted when? The original
This
one?
18 notice was prior to 25, my lord. And thereupon now this impugn order has come in 25. My lord, and my lord, this point was raised, and if I read wrongful declaration of Waqf, any government property identified or declared as Waqf property before or after the commencement of this act.
No, Mr. Roy Choudhury, what is concerning us is you have proceeded, on the presumption that it's Waqf property.
Waqf property.
There cannot be any presumption.
My lord,
You have to first, if your entire edifice is foundation is it's Waqf property, you have to establish that it's
My
Waqf
lord,
property.
my lord, I
By
have got the
stating that
chitta
it's Waqf,
today.
the
My lord, I have got the chitta.
Chitta is not Waqf property.
My
Chitta
lord,
is.
there, if it would have been government land, sorry, my lord, there they would have written Sarkari land. They have not written Sarkari land. They have said reserved for Kabastan.
Will it be enough?
My lord, that is using the automatic, the Islamic Waqf Act will come, the trust will come. That is the general law, my lord, Assam Land and Revenue Regulation. And this is a special law.
If this was coming from the government side, problem would not have been there.
My lord, because I have
They are not saying so.
My lord, they are not saying so because they have done the wrong.
And if they do not say so, the burden is still upon you. Only after you discharge your burden, the owners will shift.
My lord, I have placed my submissions before the revenue authority, which was given to me by the direction of this court, to find out.
Have you put anything before the revenue authority?
Yes, my lord, I have placed it.
To establish that this property
We have
consists
raised
as
the
a
point
property.
through the chitta that this is.
Chitta may not be enough.
But they should
Chitta
put
may
have
not be
gone
enough.
for an inquiry. They could
Either you can have a deeming clause. There can be a document that this property has become
My
a
lord,
property.
at present I have got this chitta today, my lord. This chitta I have not annexed earlier, my lord. Your lordship will fix it on 21st. In the meantime, that document of my lord Waqf property, I will place it before your lordship. That this is our Waqf property. Because 70 years back, the land, with due respect, my lord, during that time, Justice Hawk was there, who has made a conference and declared that this is a Waqf property, and this Waqf property has been governed by the Kawastan committees. And there is a civil suit pending between the tenants and the landlord, and there was an injunction not to evict us. And even, my lord, when there was a dispute between two Kawastan committees to whom we will pay the rent, my lord, we went to the deputy commissioner.
Mr. Kolita is for whom?
He's one of the Kawastan committee.
And Mr. Dhar?
He's also for one of them.
On the issue that lordship.
There is a dispute inter se, my lord, who is the proper person?
Committee.
Committee.
There is a dispute between Mr. Kolita and Dhar.
And that is
Not
established by
that-
trial court.
I am not a committee, I am a tenant.
I know from your
There is a
response,
dispute between
there
them.
is dispute between them. So one of you should come to this side, I think.
Yes, because otherwise, lordship, I have also been implicated lordship, after filing agreement petition for respondent number 6 to 12. They are also lordship, different stakeholders of Coverston, and they are also lordship, they are supporting.
Some
the
miscases
government,
also there, where the other
Supporting-
Mujib,
Are any one of you supporting the case of the
well,
petition?
some of them have
He is
filed a
supporting,
application.
lordship, that is always lordship raise this issue. First issue is that lordship, if lordship publish within 1 minute's time to show
No,
the.
we'll have on the appropriate occasion, not to
Yes.
say.
21st, well, let it be on
Because
21st. Some urgency is
The
there.
person lordship who has been restrained by the line of civil court. Now this person is lordship always present to the court to stand in my side, to be conflict that there is two committee. Trial court has lordship specific order is I have annexed in my reply, if it is in opposition. Trial court has categorically restrained this person to be acted upon as a committee of the Coverstan. Still, Lordship, in High Court, they are Lordship insisting that we are the committee.
So standing by your side doesn't mean that he's your friend.
Yeah, of course, Lordship. He is supporting the only petitioner. And when the respondent will support the petitioner, the
Some of the
intention, Lordship,
budget
that is
committees has
transparent.
come with a miscase
Yes.
that they are supporting because the Kabustan committee is run by the tenancy, rent
When-
paid by the tenant to the Kabustan committee.
The entire
And
Muslim
the
community
whole
is also
committee is
supporting to evict that illegal
Some
person.
Muslim committee has
Only
also
this
come to
person
support us.
Supporting not to evict this person. So Lordship will, the picture is there, Lordship. And my learned friend, initial, the very beginning of this argument, he said that I am not interested to argue before this court. Last 15 years, I have been practicing
No,
this
no, no,
court.
don't go by
Yes,
those, don't go
because
by those.
he-
We are not,
he
we are not,
only-
we are not, those are very small matters.
Yes.
These are not matters of arguments.
It's a private matter, Lordship, that's why I raised the question.
Again, he is raising the question of part, but I don't know where from.
Yes, language skill says interpretation is not necessary. For further
Interpretation of
hearing,
language, I don't know man, for what
He
reason.
may not know, Lordship.
I leave it to the learned, esteemed councils to whomever before court you
Yes.
may like. There are two bench five. You can try here. You can
Your
try
lordship
somewhere
may fix it
else.
on 21st, well, these few days I have to.
21st.
Lordship, only issue is that on last occasion, the court was tried to dispose of this petition on that day itself. He Lordship requested many times, even at 2 PM, he requested, please give me only accommodate to 1 week time so that I can take proper instruction when they will Lordship vacate the land. That
Is
the-
there anything in the order, my lord?
No,
Is
order
there
is
anything-
necessary. Order is not necessary.
Okay,
Lordship.
okay.
In
Those
every
are
time,
not-
order is not necessary.
Those are not the subject matter of
Yes.
dispute.
And now today, that is why Lordship, he is not inclined to argue this before this, Mr. Justice Equinay, Lordship. Because today was supposed to dispose of this.
Okay, but 21st,
21st, man.
come prepared, whichever court.
My lord. The interim order to continue, my lord, because you still put it.
What is the interim order?
Because not to evict us, my lord. Very first day, my lord, Justice H. Shrike, my lord.
Okay. Affidavits have been exchanged.
Exchange.
I have filed by affidavit.
And Dhar, will you file or not?
Government has not filed.
Not supporting the petition.
Supplied with any of the affidavit filed by my friend.
What is necessary? For impeachment petition, I have filed. Not necessary at all. I have only filed impeachment petition. I have served the copies of petitioners only. Why should I file it to the respondent, Lordship? Impeachment
No,
petition.
no, those are small issues. Why are you fighting on that? Fight on the issues.
That's the Lordship.
No, have you
Government
filed,
filed an affidavit.
have you filed affidavit?
I have filed my.
Give a copy, let him also know. Otherwise, it may again be delayed.
But otherwise, Lordship, it is.
No, 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 everyone should have the
Yes.
pleadings, copies of the pleadings. And it all depends on Mr. Borpujari.
Yes.
He's in the middle. He's friend of none.
He's friend.
Be
of-
careful.
He's only the friend of government.
Okay, 21st. Pleadings, further pleadings are to be exchanged or what?
The government has not filed any affidavit, but it is not required because we will go by the speaking order. Everything is inculcated in the speaking order itself.
Okay, okay. As requested by the learned counsel for the parties, list these cases, one case or two cases?
One case.
One.
List this case for admission hearing on 21st, for 21st of August. Further pleadings, if any, to be exchanged before that.
Interim order.
Interim order passed earlier to continue till the next day of listing.
Obliged.
Okay.
Obliged.
Obliged.
Regarding the refund part, madam. The proposal was submitted by the commissioner to the government, madam. Now it has been returned back, madam, with certain queries, madam, to re-verify the claim. And madam, they are saying that within 1 week, it will be, madam, again forwarded to the government, madam.
This is taking a long time. Heard Sri A.B. Kasta, learned counsel for the petitioner. But I also heard Sri B. Gogoi, learned additional advocate general Assam, appearing on behalf of the sole contender. Sole respondent.
Yes.
Don't say.
No, there are 3 respondents.
Appearing for the respondent numbers?
2 and 3.
2 and 3. He has submitted that written instructions dated 11/8/2025 has been received, as per which some more time would be required for a re-verification. He, however, assures that the matter would be brought to a logical conclusion within a very short time. let this case be listed after 2 weeks to enable,
10 weeks, Lordship.
2 weeks to enable him to obtain the up-to-date instructions. Full stop. List on, yes, tell us, madam.
My lord, let it be on, my lord, in that
Two
case
weeks.
on
We'll have it on 27th.
27th or 29th.
29th.
29th. Obliged, my lord.
Okay, Your Lordship.
Yes.
Here,
20
Lordship, this respondent has filed a affidavit, Lordship. So, Lordship, 1 week time may be approved to file a reply.
You are for, Mr.
Lord, I am for the private respondent.
You have
Respondent
filed
number
affidavit,
5.
Mr. Bhattakur?
I have filed it.
What is the matter?
What is the matter, Your Lordship? Ultimately, probably. Your
You are the
Lordship-
writ petitioner.
Lordship.
I have for what?
No, I am
No,
for
no,
the
not. He is the writ petitioner. I am for the respondent number 5.
I, Lordship, only for some, at the time of passing the.
Your Lordship can dispose of the matter, Your Lordship. In fact, Your Lordship may kindly come to the prayer, Your Lordship.
I have for what?
I, for Lordship, first order, Lordship, some typographical error was there. To rectify those errors,
We have done it.
it has not been done.
Now, what is your, if Mr. Bhattakur says that it can be disposed of, let us
But
dispose.
no, Lordship. We have to file our reply.
No, no,
because-
if it is, if the proposal which Mr. Bhattakur would give is acceptable by you, you can, you have no, he has not even said what is the manner of disposal, what do you
Lordship,
say?
he wants the directly respondent number 3 to supply all necessary documents along with the complaint petition of miscase number so and give the petitioner a reasonable opportunity to file his written objection against complaint lodged by the respondent number 5.
You are for the 5, respond number
5,
5.
Your Lordship.
We'll direct you.
That will be provided and this can be disposed
That
of.
can
Your
be- just let them provide that document in court, Lordship. Otherwise, again,
no,
we have
we'll
to-
give her
again, we have
time.
to run to them, Lordship.
No, he'll be in contempt, we'll give him 15 days time or.
Yes, Lordship, that can
Which
be done.
time, okay. Who are you, Mr. Bhattakur?
Your Lordship, I have also applied under Bosundhara, Your Lordship, for settlement of a plot of land, Your Lordship, which he claims, Your Lordship, that his son has applied, Your Lordship.
Lordship, there are some other players also, Lordship, in paragraph, in page number 16 and 17. Here, Lordship, only the circle officer and the allotment, the Lordship. Those two, Lordship, respondent has been playing the actual game. So, Lordship, another
Just
player is,
let us see your prayer.
yes.
Page 9.
Page, Lordship,
Page
16.
16.
First paragraph of the Roman 4, direct the respondent number 3 to supply all necessary documents along with the complaint petition of miscase number so and give the petitioner reasonable opportunity to file his written objection against the complaint lodged by the respondent number 5. Direct the respondent number 3 not to pass any final order in miscase number so without hearing the petitioner along with his written objection if any. Direct the Commissioner of Police to register a case against the respondent number 4 who has threatened the petitioner to send him to heaven and arrest the respondent
You
number 4.
should be very happy.
Because Lordship,
He has not said to hell.
yes,
He'll
because
send you to heaven.
Lordship, because
Everyone
this
deserves
person-
to go to heaven, not to hell.
because these two persons, Lordship, 3 and 4, they, Lordship, personally.
Did
I
you,
have- no,
did
Lordship,
your the client make such a statement, made such a statement?
Lordship, because this 3 and 4.
Obviously, you'll say no.
Respondent number 3 and 4, Lordship, they will personally, Lordship.
He will go
trying
to
this
heaven.
person.
For these, Your Lordship, appropriate remedy is available to him, Your Lordship, under BNS.
Okay. Heard Sri J. Kolita, Learned Counsel for the petitioner. Also heard Sri N. Das, the Learned State Counsel for the state respondents. Whereas Sri S. Bhattakur, Learned Counsel has appeared for the respondent number 5.
Yes.
Full stop. Considering the grievance expressed and after hearing the Learned Counsel for the parties, this court is of the opinion that the writ petition can be disposed of at the admission stage. As per the facts projected, the petitioner had applied under the Basundhara scheme number 0.2 for grant of land. Please have your seat, both of you. Full stop. However, the respondent number 5 had raised certain objections and had also filed a complaint. And accordingly, an order was passed on 10/11/2023 for stop construction. Full stop. It has also been averred that the respondent number 3, along with the respondent number 4, have been threatening the petitioner by implicating him falsely in a land grabbing case. Full stop. Para. On the other hand, Sri S. Bhattakur, learned counsel for the respondent number 5, while denying the allegations in toto, has submitted that the relief sought for in this writ petition are not even opposed by him in principle. Full stop. He has submitted that there is no objection from his client to supply the necessary documents along with the complaint of miss case number 28/23-2024 pending before whom? Pending
Lordship,
before?
I have submitted a complaint, Your Lordship, that is part of my affidavit in opposition, page
This is
87.
pending before whom?
Your
But she lost.
additional deputy commissioner, Your Lordship,
Before the additional deputy commissioner, which place? Kamrup?
page 80,
Kamrup.
only Your Lordship, a complaint, Your Lordship, there is no other documents.
No, he has, he has documents now. Supply the copy of the complaint in Miss case so-and-so, huh? He has clarified that no documents were filed along with the complaints. Full stop, para. For appreciation of the rival claims, the relief prayed for is necessary to be looked into, which reads as follows. Paragraph 16, huh? Page 16. From the aforesaid, comma, it appears that the issue which this court is required to look into is regarding a direction to the respondent number 3 to supply the necessary documents pertaining to the complaint lodged by the respondent number 5. Full stop. As regards the other relief, comma, the petitioner would have all the liberty to approach the appropriate authority to deed on it. Full stop, para. As recorded above, comma, the learned Sri Bhattakur, the learned counsel for the respondent number 5, has undertaken to supply copy of the complaint petition in miss case number 28/23-24 to the petitioner. Full stop. Para, in view of the above, comma, let the respondent number 5 supply the, but how will you supply?
Through circle officer, Your Lordship. He is the, Your Lordship, who is holding the.
In view of the above, comma, the petitioner as well as the respondent number 5 are directed to appear before the respondent number 3 on, we give a date. Yes, we give a date. Your assistance will be required.
Any date will do. After 1 week, any?
Huh?
After 1 week.
We call it last one. Directed to appear before the additional deputy commissioner, district commissioner.
No, my lord,
Circle officer.
Circle officer.
Circle officer.
Guwahati Revenue Circle on 22nd of August 2025, on which date the respondent number 5 would furnish the documents pertaining to the complaint petition to the petitioner. Full stop. It is needless to state that the proceeding, that in the proceeding before the respondent number 3, the petitioner would be given a fair opportunity to represent this case.
He will appear along with a certified copy of this order, man. That must-
Why? You are there, he'll have an online copy. What is the problem?
Online copy?
If there is difficulty with 22nd, you can just inform us. We can, you, all three of you, you consult your clients. 22nd, they may not be available at Guwahati. But we are more concerned with the circle officer.
Lordship, does this conduct lordship is not fair, Lordship.
Whose?
Respondent number 3, Lordship.
Is he by party by name?
No.
As a circle officer, Lordship, he has been made party, but not.
Circle officer?
Yeah.
How? If you say that he is not fair, you have to make him party by name. Today there is one circle officer, tomorrow there may be another.
Yes.
Okay. Repeat both the repetitions as well as I can dispose of. I have to believe I report in view of the final orders passed in the connected writ petition. I still dispose of no order is required to be passed. Yes, next. Item number 24 R. Borua. Maisana Laskar. Rishikesh Das. Where is Rishikesh Das? Is Das? No, he was in. He was seen in the court. Yes, none appears for the petition applicant on call. In the interest of justice, matter is adjourned to be listed after a week. Yes.
My lord, the petitioner before lordship is a firm. They registered micro, small and medium enterprise, MSM. Now as a lordship knows that the.
Which way? There are two writ petitions.
My lord, I am on number 1, my lord, 2705.
Keshari.
Keshari, yes.
And what is this I about?
Now, I is, my lord, in place of, there is a government notification in terms of MSME, that is notification dated 29/5/2015.
Yes.
In terms of that, my lord, the banker, in order to realize the amount, well, instead of going to SARFAESI, they will have to give a chance so that the matter can be referred to the committee for any kind of resolution. That was not done in this case in spite of our request. My lord, your lordship may see.
You are an MSME.
My lord. I'll just take your lordships to that request that.
LLP can also be an MSME.
Yes, my lord. It's a registered MSME, my lord.
What is your business?
Business is, my lord, these plastic bottle, then bags and all that. That we have stated in our petition. Your lordship may see.
You are contending that the procedure prescribed for an MSME before following a recovery proceeding has not been done.
Yes, they ought to have, my lord, I have prayed for.
Yes, Mr. Sharma.
Your lordship, they are not fall under the criteria, eligibility criteria that has been given at page number 106 of the writ petition. That is the.
But
limit
if
is-
they are registered as MSME, then is there any further what do you call it, classification required?
Yes. Your lordship, I am not going into the classification. Their total exposure is 34 crores.
Yes.
And eligibility criteria is 25 crores, page number 106. So they exceed their limit. So there is no applicability of restructuring under the committee by the MSME. At the very first site, your lordship. And second, we have already taken the.
34 crores.
Yes.
106 of what?
106 of the writ petition.
You are not micro, you are macro.
Sorry, your lordship, 206.
MSME but macro, not micro. 34 crores is huge.
Besides that, the internal dispute between the partners keep going on. The entire story is being written in the rate petition.
You are an LLP.
Yes, yes. That's the length.
Yes.
Eligibility, para one.
And who is for the other petition?
Other repetition,
2171?
that is, my lord,
You are the counsel.
I'm the counsel in that.
And in this case,
Taylor is your surname or your, what is your surname?
Taylor is the surname here.
Surname,
Surname.
not your profession.
I don't think, my lord.
Earlier, it
Right,
is
for the-
just
I was
profession.
thinking that
I
initially.
heard for the first time Taylor.
In Australian
Possibly-
cricket team, we have heard Mark Taylor.
No, that's a different,
Yes.
T-A-Y, not I. This is Taylor, this
Yes,
is
sir.
Taylor,
Taylor.
T-A-I.
I think it's a title, not the profession.
Sampat Kumar Taylor. You are connected, Kesari and Sampat are
Yes,
connected.
sir.
It's connected.
Sampat Kumar Taylor is the guarantor to the KC International Udyog, who is a respondent number 3 in the writ petition.
Intrinsically connected, not only connected.
It's me. My lord, my learned friend is instructing me that this
Not to
case-
press.
No, it's not that, my lord. Pressing, so far this case is concerned, my lord, in regard to SURFACE action, we have the liberty, your lordship may see section 17 of the SURFACE Act.
Okay, 17 years appeal.
So therefore, my lord, can I pray to your lordship to give a direction to appear before the authority?
What about the limitation?
Yes, that is the question, my lord. There is within 45 days from the cause of action, we are to file an appropriate application. So therefore, if your lordship.
We can have it tomorrow? You take
yes,
proper instructions.
my lord, that can be done.
Because this will make a paradigm shift, no? The entire
Yes,
issue will
yes,
be,
yes.
now if there is a.
So it's better after
some-
taking an
yes,
instruction.
Yes,
if I-
some error in understanding, then there will be difficult.
My
Take
lord.
your time, we'll have it tomorrow.
All right.
Heard Sri as Dr. Leonard Senior Counsel, assisted by Miss what? P. Bhagat. What is your name, madam? P. Bhagat?
Hey, bolo na.
P. Bhagat, yes, your lordship.
P. Bhagat, for the petitioners. Also heard Sri M. Sharma, Leonard Counsel for the respondent bank. Para? Respondent bank, who has submitted that the amount involved would that the amount involved is 34 crores.
Yes, your lordship.
34 crores, which is more than the
Eligibility limit of 25 crore.
eligibility limit, full stop. Para, at this stage, the Leonard Senior Counsel for the petitioners has submitted that some time may be granted so as to enable him to take further instructions on the future course of action. We are not saying anything tomorrow.
Yes.
List tomorrow.
My lord, day after tomorrow.
Day after tomorrow. Tomorrow will not be there or what?
Beg your pardon.
Tomorrow?
No, I'm here, but then there are a lot of, my lord, I'm loaded tomorrow.
You are making the submission just within one minute. I am giving you 24 hours. Tomorrow at one point of time you come.
All right.
Nobody knows what is going to happen
Yes,
day
yes.
after tomorrow.
Yes, very, very fair. Much obliged.
Yes, next. 27 G border. Yes.
May please, your lordship.
Yes.
Lordship, as per Lawajima Court's order, service has been completed upon the respondents. Matter may be fixed next week for admission hearing.
Peruse the order dated 11/8/2025 passed by the learned Lazima Court. The service upon the respondent numbers 4 and 5. No, the endorsement regarding completion of service of notice upon the respondent numbers 4 and 5 is accepted. Full stop. List for admission hearing after a week.
My lord, kindly date may be given.
What is the subject matter?
Lordship, non-implementation of eviction notice.
Eviction notice. We'll see one last after a week. Yes, no problem. Yes, next.
Problem.
Iqbal Khan, please come. 17 matter. Oh, 11 can again. Sunny. Daily? 11 key. Hearing.
No, some,
Hearing,
some other.
it was 16. Oh, that is 16. 16 then, 16. 11, Mr. Sayana, please come. Gopal Krishna.
Record as directed by this honorable court that we have received, my lord. Maybe taken up some other day, my lord, immediately after.
Oh, 17 matters. When?
Yes, my lord.
Tuesday next.
Immediately after Independence Day, my lord.
When Tuesday next?
My lord.
When Tuesday next.
All right, no problem.
Okay, heard Sri G. N. Sahara, Learned Senior Counsel, as well as Sri B. Goswami, Learned Additional AG Assam. The Learned AAG has submitted that records have been received and has prayed for listing of this matter on any other date. Para? Considering that this writ petition is of the year 2016, list for hearing on Tuesday next date.
Yes, obliged.
Well, UCO Bank.
Yes. Hello, my lord, before,
UCO Bank versus Assam Financial Corporation.
my lord, now, my lord, the Decision Supreme Court judgment says, my lord, all matters relating to DRT and Surface Act will, High Court will not interfere, my lord.
It will
That
go
is
to
my
arbitration.
preliminary. So their contention, my lord, you will also be pleased to hear them.
No, if there is a consensus, we should not go deep into it.
Which latest judgment that I see them. Anyway, my lord, let the matter be finished.
What is your challenge, Mr. Sawala?
No, my lord, what happened, my lord? Here, we have filed a suit, my lord, for the cooperative land. Here, my lord, because the finance was done by, my lord, both the parties, my lord. Because Assam Financial Corporation has made 22 and we have made 37.5%.
To a party, third party.
And then
You had instituted a suit.
Yes, then we filed a suit, and the suit was decreed, my lord. There, my lord, we have made the Assam Financial Corporation as a
Pro forma.
Yes.
Pro forma. Then?
Now the suit was decreed.
Yes.
If your lordship will see, my lord, at page 19.
Yes.
The decree, because it is a civil court, my lord. Last portion, A.
Yes.
For the plaintiff, the suit is decreed ex parte with a preliminary decree with cost for realization of loan amount of rupees 1,82 lakhs so and so with a future interest so and so till realization of this amount. It is further the decree that the defendant number 1 to 3 shall repay the decreed amount within 1 year from the date of the filing. The plaintiff shall be entitled to final decree as per so and so. Proper defendant. The suit is decreed ex parte with a preliminary decree with cost for realization of rupees 25 lakh so and so. This is their findings. With a future interest on the decreed amount till realization of the amount, and is further decreed that the defendant number 1 to 3 shall repay the decreed amount within so and so. Well, this suit, if you also see, this decree was passed in 24/8/94. That very 11, 24/8/94.
Okay. Now, what is your, what is the dispute with AFC?
Dispute what happened, my lord? This decree was never put to put to
Execution.
by them, my lord. We filed an execution case and we put the decree on execution and we obtained the amount. Our amount was, well, because so far we are concerned, our amount we would not receive, my lord, or whatever we got, we taken away. My lord. Because by this time, my lord, that was barred.
The execution proceedings had
Yes.
culminated.
Yes, terminated.
Now, what about the share of the Mr. Kalitas,
We have
Mr.
exhibited-
Kalitas clan?
We have exhibited, we got the amount, my lord, which is does not cover even our, my lord.
Less amount.
Yes.
Hmm.
Okay.
Thereafter?
Thereafter, my lord, they preferred an appeal before the preferred tribunal. My lord, which is at page 35.
Appeal against what?
Appeal against that this execution of DRT. The execution was done by.
No, cannot be. How can it be an appeal in the DRT against the civil court?
That the suit was filed before the learned civil judge, and later on under section 31 of the Recovery of Debts and Bankruptcy Act, it was transferred it. Because at that time, the Recovery of Debts and Bankruptcy Act come into force on 1993. And thereafter, all the matters pending before any civil court, more than rupees 20 lakh has been transferred to the.
Transferred?
Yes.
Who, the adjudication was by whom then?
Execution was done, my lord. DRT, well, civil court has done.
At the execution proceeding?
We
it
have
had-
continued at DRT.
DRT, okay. Okay. The suit was instituted prior to the 1993 Act.
Yes.
The suit was instituted prior to 1993.
Okay. In the meantime, 1993 came.
Yes.
And as per 31, the matter got transferred. Okay.
Well, now we got the amount, my lord, whatever, my lord, partly it was covered.
Then
Then-
who filed the appeal?
Appeal was filed by the Assam Finance Court
In the DRT?
in the DRT appellate tribunal.
Aggrieved-
Yes,
aggrieved-
DRT, the tribunal.
Aggrieved by what?
No, this DRT tribunal, my lord.
DRT tribunal, aggrieved by what?
Agreed by the execution order, my lord. Execution order,
They filed 17 petition or what?
yes.
17 petition or what?
Yeah.
Lordship, that's page number 31.
Yes.
Page number 31, my lord. That is the order, my lord.
That is the initial order, thereby the execution has been started.
Yes.
Then
And
the election-
accordingly, we have executed the recovery certificate
Yes.
and we received some amount. And after receiving of the amount, DRT recovery officer has released the entire amount to us. And we have received the amount and adjusted in the loan account. But by that order, Assam Finance Corporation has been aggrieved and they have preferred an appeal under section 30 subsection 1 of the Recovery of Debts Act.
Sorry, reconcile. Recovery of.
Oh, sorry. DRT.
Final order.
इसी का उधर मतलब ये सब है यार इसमें लेकिन कैसे हुआ
It's appeal against the order of the
See, 30 envisages is.
One.
Envisages an appeal by any order passed by the recovery.
Because
officer.
execution was done by the recovery officer.
But the original proceeding, which was in the nature of a suit, was conducted by the civil court.
Civil court.
The decree was passed. At the time of execution, it got transferred. And if you see, it's an OA, 39 of 2002. An OA is before the presiding officer, not before the recovery officer. You may be correct in contending that the execution is done by the recovery officer. Where they aggrieved by the action of the recovery officer.
Passed by the presiding officer.
Recovery officer.
Order was passed originally at page 31.
Yes.
The order.
That is by the presiding officer.
That was presiding officer.
Against this, there will be no appeal under 30.
My lord, execution was sought.
उसके बाद में ये execution
Thereafter, my lord, the execution was carried out.
Against the
As
execution
per this
order.
As
Okay.
per this order.
Mr. Kolita's client has filed appeal.
Yes.
Thereafter, what happened?
There, my lord, in that case, the appeal was dismissed with the observation, my lord, page 42.
Number 6 register petition of contract. No. Here. Observation to delay. No.
Appeal dismissed.
Appeal was dismissed, but observation is made, my lord, that we shall get 37.5% and they will get 22%. That was at page 42. My lord.
The sale proceeds of the mortgage process.
Self-mortgage.
And 37.5% by your bank, Indian
My
bank.
lord, yes, my bad.
And AFC?
22%.
Okay.
My lord.
Thereafter?
Thereafter, my lord, appellate tribunal, my lord, we preferred an appeal before the appellate tribunal.
Which is impugned
Before the Sonora court, my lord. Which is at page 5, annexure 5, page 43.
Okay.
And by this order, my lord, not only dismissed, my lord, an amount of rupees 50,000 was imposed as cost.
Against you?
My lord, against me.
By the appellate tribunal.
And that is the, my lord, from his account, my lord, the person who has, my lord.
Appeal dismissed. With cost. With cost of 50,000. Appeal dismissed.
Appeal dismissed. Yeah,
Now you are challenging that order.
Yes, my lord. We are sending this. As well as subsequent order, my lord.
Mr. Kolita, what is the decision you are trying to? There is nothing pending before the tribunal or the appellate tribunal. This will not be usurping of jurisdiction. They are aggrieved, they can come before the court, final orders.
Immediately.
Had it been an ongoing proceeding before a DRT, we would not have laid our hands. Satyavati Tandon, later cases, all very clear. You send it to the tribunal. Now tribunal has got nothing to do. Even the appellate tribunal has passed final orders. That can be looked into. Whether they are successful in marriage, that's a different matter.
No, my lord, their first contention is not fully correct, my lord, because you lordship may be pleased to see page 20.
20,
my lord.
Yes, please.
The decree of the district judge.
Yes.
Page 20, note B.
Yes.
For pro forma defendant, the suit is decreed ex parte with the preliminary decree with cost for realization of rupees 23 lakhs so and so. Then says, last line, my lord, pro forma defendant shall be entitled to final decree and peripesu charges and in the ratio of 22:30.37.5.
Yes.
I have said that.
It is always there, my lord, because they are the plaintiff. They are to pray for final decree, my lord. I cannot pray. We took the different steps, my lord. In our affidavit, we stated an order was passed by the same district judge, my lord, in 2015. That was disposed of 2015. Lastly, my lord, in my affidavit in opposition, because they are taking, their contention is that our claim is barred by limitation. That was also discussed, my lord, fully by the learned district judge. They have suppressed all these things, my lord. In our affidavit, we have stated, page 42 of my affidavit in opposition, my lord.
Which page is 12/12/2013?
Page 42 of my affidavit in opposition.
43, no, 43, 81.
42 of my affidavit in almost last portion, my lord. Page 42.
Yes.
Third parameter, from the order, it reveals that the case was proceeded ex parte as the opposite party did not contest the suit. In the said order, it was reflected that as per the ex parte statement given by the assistant manager FCI, the petitioner corporation has been able to establish their claim in respect of the loan money amounting to rupees 23 lakhs and others. And the interim order of injunction passed so and so by this court is made absolute and the mortgage property was directed to be sold. Last order was passed on 17/11/2001. From the said order, it appears that due to non-appearance of the petitioner, the further execution proceeding was stopped for want of steps. Accordingly, the execution case was filed. But due to pecuniary limits, the same was transferred to DRT, Guwahati, for its further proceeding, and the mortgage property of the defendant was sold by way of auction, sale, and recovery officer has released the amount of rupees 1 crore 8 lakhs in favor of the UCO Bank. Against the said order, the opposite party has preferred an appeal in DRT, Guwahati. Admittedly, the court of the district judge Bongargaon had decreed the suit in favor of the petitioner UCO Bank in the ratio of 22.37.5 basis. And as per the judgment of the civil court on 24/8/1994, the defendants were directed to repay the decretal amount within 1 year. And in default, the petitioner and the plaintiff UCO Bank in title suit number 9/92 are entitled to apply for final decree. Accordingly, a petition for execution of the preliminary decree was filed by the UCO Bank before the court, and ultimately the same was transferred to the DRT Guwahati, and DRT Guwahati has issued a certificate in favor of the UCO Bank for realization of the decretal amount with interest and cost from the defendant in accordance with the terms of the decree of the civil court. It is seen that the petitioner has ever applied for issuance of final decree in default of payment by the opposite party in terms of the civil court decree or made any claim in the execution proceeding filed by the plaintiff in TS 9/92 of UCO Bank. It appears that the petitioner has neither filed any execution petition before the civil court nor any application before the DRT Guwahati under section 31 of the DRT Act. In the appeal 6/2010 before the DRT, it was held that the issuance of certificate in accordance with the terms of the decree passed by the district judge on 24/8/94, the respondent is entitled to the ratio of 22.37.5 basis only in the sale proceed of the mortgage property. As such, excess amount received by the respondent number 1, that is UCO Bank, over and above their share in the action sale proceeds, is to be refunded to the learned recovery officer. The learned recovery officer will receive back the said excess amount along with interest at the rate of FDR in the intervening period and put the same in the nationalized bank in an interest-bearing account. It is also reflected in the order that the learned recovery officer will hold the amount till other assets of the certificate holders are sold out and the amount under the certificate is realized. In the meantime, if the appellant bring any order from the competent court of law for release of their share in the ratio of 22.37.5, the same will be released in their favor. Otherwise, the amount will be released in favor of the respondent number 1. It is also alleged that though the petitioner was entitled to a sum of rupees 40 lakhs 11,000, but the pro forma opposite parties UCO Bank withdraw the entire amount of rupees 1 crore 8 lakhs from the office of the Debt Recovery Tribunal. After receipt of the amount by the UCO Bank, the petitioner via letter dated 19/5/2008 requested the UCO Bank to forward the part of the sale proceed of rupees 1 crore 8 lakhs received by the UCO Bank after action of the mortgage assets of the unit of the opposite party, but no action was taken from the side of the UCO Bank. Due to the illegal action of the UCO Bank, the petitioner had to file an appeal by appeal number 610 of 2010 before the DRT Guwahati. In the said order dated 9/1/2012, the presiding officer DRT Guwahati specifically held that the respondent number 1, that is UCO Bank, is entitled to their share 22:37.5 basis and the sale proceed of the mortgage property. Against the judgment and order dated 9/1/2012, the UCO Bank preferred an appeal before the Debt Recovery Appellate Tribunal at Kolkata, filed appeal number 64/12. The learned Debt Recovery Appellate Tribunal, Kolkata, dismissed the appeal.
This order was passed by the district judge Bongaigaon.
Yes,
correct?
my lord.
Now,
Yes,
this is 6/4/2015.
these things were considered, my lord.
6/4/2015 order.
Yes. Your lordship, lastly, this is the final order passed by the DRT, my lord, at page 55. They have enclosed, my lord. 4/7/2017, which was considered by the learned DRT in the last order, which they have challenged now before your lordship. That is at page 81. Last order, my lord. 15/9/2017.
Yes.
This case is called out as per previous order. The tribunal has passed final orders on 4/7/2017 and inter alia passed an order imposed cost of ₹50,000 upon the certificate holder bank, that is UCO Bank. The recovery officer was directed to place the status report informing as to whether the cost has been paid by the certificate holder bank. The recovery officer has placed the report before the bench, and it is found that the certificate holder bank has neither paid the cost nor have complied with the other orders passed in the judgment. Hence, it is evident that the certificate holder bank has disobeyed the order of the tribunal. In view of the above, the Deputy General Manager of UCO Bank Guwahati is directed to appear in person on the next date of hearing and also show cause as to why appropriate proceedings shall not be initiated against it. Against this order, my lord, they have come before your lordship. Now, the important order is, my lord, at page 55. Wherein the, of their petition, my lord. Wherein the Honorable DRT, my lord, fully discussed everything, including the point of limitation that we have not filed any execution case, etc. All things were considered, my lord. And finally, my lord, they have observed at page 74, my lord, I am not reading the entire order, page 74, my lord. From the above, it is evidently clear that the appellant bank is holding an excess amount of their shares for which an order has been passed to deposit the same with the learned recovery officer, and has also been made clear that this amount received by the learned recovery officer will be released in favor of the respondent number 1, now appellant, if the amount so received by the respondent number 1 is found short in terms of the certificate issued, but not earlier than 3 months from receiving back the same amount by the learned recovery officer from the respondent number 1 bank. Hence, it is evident that unless the amount is given back to the learned recovery officer, there is no question of giving this amount to the appellant bank, even if it is found short in terms of recovery certificate. Secondly, this amount will also be given only after 3 months. However, moreover, the amount will be given only if, after selling the other property, still the appellant bank is short of the amount to be recovered. When the appellant bank has not deposited the amount to the learned recovery officer, the question of running the period of 3 months does not arise. Moreover, it is evident from the order dated 28/8/2014, the learned recovery officer, that the appellant bank is yet to give details of other properties of the CDs to enable him to sell and recover the amount. The say of the appellant that the money is safe in their hand, and as and when the order will be passed by the learned tribunal to refund the amount on account of being decree filed by AFC, the appellant bank will refund the amount
Is totally unbelievable.
Is totally unbelievable. When the appellant bank has disobeyed the order of this tribunal passed on 9/1/2012 and confirmed by the Honorable DRT Calcutta, the question of believing the officer who has signed this review application of such bank does not arise. The appellant bank has already violated the order of this tribunal by not depositing the amount with the learned recovery officer. The appellant bank shall
comply the orders passed on 9/1/2012 immediately. Since the appellant bank has violated the orders of this tribunal is challenging the order of the landed recovery officer, thus to avoid compliance of order dated 9/1/2011 and exemplary cost of ₹50,000 is imposed upon the appellant bank. The cost shall be paid within 1 month, etc. So this is the initial order, my lord. Thereafter, as they have not complied with, my lord, this final order was passed on 15/9/70, directing the officer.
Now, what is the present status? Have you got any of the amount? That apportionment of
Present amount,
37.5?
my lord, more than 99 lakhs. It is a perhaps, my lord. at
What is the
time of
present position, Mr. Sayola?
My lord, one thing I must submit, my lord, here, the final decree, if your lordship will see, my lord, that at page 29B, my lord, final decree does not say, my lord, it says that it will be applied and it will be paid to the decree holder, my lord.
No, have you apportioned
My
the
lord,
amount?
No, here, my lord, first thing, my lord, the final decree does not say, my lord, that the amount first that will be paid to us, my lord. So our amount has not been covered that, my lord. That they have not applied for final decree, my lord. They have not applied for final decree. We have applied for
We
final
cannot
decree,
apply,
my lord.
because they are the plaintiff.
Yes, and they have not also gone for execution, my lord.
They can obtain the final.
They can obtain final decree because they are in the order. My lord, if you also see, my lord.
Final decree is passed in terms of the preliminary decree, my lord.
That's
And
correct.
they are the plaintiff, they are
My
to
lord,
file.
I-
I
I'm
cannot
just-
file.
I'm just.
I am a dependent in that suit, my lord.
Yes, maybe, but if I will say, number 20. Page number 20, my lord, if you also see, my lord. Just page number 20, my lord. You'll also
20.
Yes, 20. The judgment itself, my lord.
99 lakhs.
Former defendants shall be entitled to.
Yes.
Yes.
The last three sentence. Whose proper defendant shall be entitled to a final decree and pari charge in the receipt of so and so. So they are entitled to apply for final decree as per this judgment.
No, it's not.
My lord?
We have to read the entire line. It is for, and it's
Yes.
further decreed
This-
that defend numbers 1, 2, 3 shall repay the decreted amount within 1 year from the date of decree, failing which the pro forma defendant shall be entitled
To a
to
final
a
decree.
final decree
And
and
pari passu charges.
pari passu charges
In
in
the
the ratio 22:37.5.
So, my lord, when they failed, my lord, they should have applied for a final decree. They have not applied for it.
We have gone to the DRT for final decree, at least number 20.
Now, how do you resolve the issue? Both of you are financial institutions. Both are handling public money. How is it to be resolved, Mr. Kolita? How is it to be resolved? Both are handling public money, both are financial institutions.
Actually, my claim is only according to the pari passu agreement, my lord. Whoever obtained the money.
Can it be, my lord, resolved with a mediation, my lord?
In the share, my lord. 22 point.
No, what Mr. Sayola is saying, whether that is acceptable or not, different. The decretal amount and their entitlement on the execution was not even meeting their part. So they had thought that the entire part they have. But what you are saying that whatever is the amount recovered in the execution proceeding, there has to be a pari passu apportionment in the form 22:37.1. That is your case.
Yes, yes.
But the entire amount, whatever has been recovered, they have
That's
taken.
why, my lord, the DRT directed them to deposit.
How much
the
was the
excess
amount in the execution?
My lord,
How much amount was?
1 crore, well, something it is there.
And
1
what was the
crore 8
decretal
lakh,
amount?
8 lakh time.
1 crore 8 lakh.
And
But it
decretal
was
amount?
kept in the fixed deposit, my lord, interest growing.
What is the decretal amount? 23 lakhs.
No, 1 crore 82 lakhs.
What crore?
Decree.
Decreed.
So far we are.
Along with interest at the rate of 16.5%.
1 crore?
82 lakhs.
1.82 crore with interest.
Yes. If you
And-
also come to page 29.
And what was recovered in the execution?
1 crore 8 lakhs.
8
around.
lakh.
1 point. Oh, not much. The difference, almost you have got everything. 1.8 crore you have got in the execution.
Yes, sir.
Actually,
What
my lord,
lesser amount, my lord?
How much was your share in the loan?
Your lordship, in the loan, we have the full share.
No, their
As per the pari
contribution,
passu, we have 37.5.
no, what their contribution in the loan?
Their approximate is 22%. 22.
No, in the decretal amount of 1.82 crore,
So far, we are concerned. It is our,
no, entire amount.
our amount, well, only. This is not theirs.
No, what is the entire amount of decree?
Yes. Entire amount of decrease, so far we are
Entire
concerned.
amount of decrease 1.82 lakh,
Okay.
along with interest at the rate of 6 lakh.
And, one crore.
What are your respective shares in the execution proceedings?
37.5
If the
is-
execution would have covered the entire loan amount,
Yes.
what is your share?
Well, 37.5 our and
I
22
have
theirs.
enclosed that pari passu agreement, my lord, along with my affidavit.
That's the agreement, Paribashu?
37.5 and 22.
No, no, it is correct. Corporation 22, bank 37.5.
What Mr. Sayola is saying is also maybe explode the mediation aspect. Will you like to, I think we can sit, there's a program of nation for mediation.
DRT tried several times, my lord. Ultimately, as there was no alternative, they directed to
DRT itself has released the money for.
appear the MD before the court, my lord. That was the order last.
No, that was for non-payment of 50,000, the cost part. That was for the cost part. That 50,000 cost was imposed. Only for that part, the MD was directed to appear in by the court. We
Yes.
have seen that order. Now, what can be done to resolve it?
Well, I think mediation,
We'll continue, we'll have this on another date. Today may not be possible. Next week, we suggested it.
Actually, my lord, what happened? As the preliminary decree was obtained by them, my lord, I cannot file for the preliminary final decree. So we filed an application under section 31 of the SFC Act, State Financial Corporation Act. And the learned district just passed this order, final order, my lord, which I have read before your lord.
Yes, yes, that,
Last portion, my lord. It is seen that in spite of the judgment dated 9/1/12 of DRT, Guwahati, and the judgment dated 31/2014, the debt recovery terminal Kolkata, the UCO Bank has not yet deposited the amount payable to
that
the
we have,
petitioner.
that we have read already.
well, at that time, my lord, the district judge has no jurisdiction, my lord, pass this order.
If your lordship direct to.
We'll have this on,
Both are financial.
on a date next week. This is an old matter. In the meantime, you seek instructions with regard to the referring the matter for mediation.
My lord, yes.
Okay, heard. Sri G. N. Sahal, London Senior Counsel assisted by Sri M. Sharma for the petitioner. Also heard Sri P. K. Kolita, London Senior Counsel assisted by Ms. T. Goswami for the respondent. Para? Both the Learned Senior Counsel for the parties are directed, have submitted that the scope of referring the matter for mediation can be explored. Full stop. Let instructions be obtained and the matter be listed for consideration on Wednesday next. Wednesday next. Okay.
Wednesday क्या बात है?
Wednesday next.
20. On it, okay.
Mr. Goswami, your matter will have another date. Will not be possible. And any other matter for interim order is still today, we can extend the date, otherwise.
My lord,
Mr. Das?
item number 15, your lordship, that matter can be disposed of, my lord.
What
As
is-
per direction of this honorable court, my lord, the petitioner has paid that outstanding amount, my lord, and no due certificate has been issued. Item number 15, lordship.
Petitioner, who is for the petitioner? Mintu Saikia, is he there?
Is not that.
Madam,
Yes, my lord. I'm on behalf of Mr. M. Shuigia.
are you aware of this matter? Can it be disposed of?
Yes, my lord.
Yes.
Can it be disposed of?
Yes, yes, my lord.
What is your instruction?
My lord, my lord, earlier morning, my lord, Mintu Saikia has said that he will withdraw this case anyway, my lord, that.
We'll have this tomorrow then. Tomorrow, come tomorrow. Make a mention, we'll try to upgrade this matter.
Item 13.
30.
If I'm
Yes. এইটো হেৰি দিবা হা এই দাস and হয়তো শইকীয়াৰ matter. Please
My
keep it.
hearing, sir, can it be placed on 26th? It's a hearing,
It's an old matter. What is the matter about?
eviction, man. It can be disposed of, my lord, but if it comes on 26th, my lord, it will be convenient for me.
26 is a long time. Why so much? We'll have it on next week. 19th is okay for you.
19th, not 19th, my lord.
Then 21st. 21st.
Will
21st. 21st for you. Item numbers 28 to 21st. Paucity of time 21st. Huh?
13 can be taken up on Friday, my lord.
13.
13.
Torun Goswami.
My lord.
What is this matter?
Well, that UCO Bank Silpukuri bank robbery. CD is missing.
Some order sheet of the
Yes, yes.
court was called for, I think.
Friday, 15th.
Friday is a
Oh,
holiday.
sorry.
Next week. Give a date. He'll give a date next week.
My
Okay.
lord.
He'll give a date.